Happy Friday Night Live. It's November. We have so much to talk about. I have whiskey. It's a heavier pour than I anticipated, but I needed to catch up after streaming earlier over on Nick Rekieta's channel with Legal Bites and Nate the Lawyer, just telling lawyer stories and talking about the things. So it was a lot of fun, but I was definitely not caught up uh, to Nick or to Legal Bites. So tonight we've got water, we've got whiskey, we've got all the things. We are talking about not only Josh Duggar, but also Tati Westbrook tonight. Yo, when I was going through a lot of you asked me my thoughts on Tati closing Tati Beauty, which has been entwined with a lot of these lawsuits that we've been talking about for the last year. It's been a year of talking about Tati lawsuits. It's exhausting for her, I'm sure. And we saw Tati Beauty announcing its official closing this week. And then there was a new filing in the Washington lawsuit that we will talk about. And it has a lot of information in it that gives, I think, context for me. It gives context. I want to know what you think. I can't wait to hear what you think. So Duggar Motions, Tati Motions, whiskey. It's been a year. It's been wild. We're coming up on the 2-year anniversary of the podcast. It's been hitting top 5 in multiple countries in entertainment news. It's been surreal. This last year's been surreal. So law nerds, thank you. Let me know where you're coming in from, what you're drinking. I appreciate you. I adore you. None of this would be happening without the law nerds. Like none of it. And it's just, this year has been incredible to get to do what I love, talk about subjects that I love, YouTube and pop culture, and bring the legal brain to the Emily brain and bring it to you all and get to geek out about, oh my God, did you see this? And what about this? And how do these things play together? It's literally the greatest job in the world. And that's because of you. And I don't have words for how grateful I am that y'all want to know about the facts too. Y'all want to know what the lawsuits say too. And then if stuff's shady, we can be like, shady. But we want to talk about the facts first and then talk about the shade. And I appreciate you for wanting to have those conversations. It really does mean the world to me. And I think the law nerd community makes the internet a better place. I love being here. I love being in this chat. I love seeing you guys and I love chatting about it. Thank you. Thank you. Thank you. Law nerds, raise a glass. Let's have some fun. Look, there's a lot to talk about. These are some heavy the Tati stuff is going to be heavy for Tati and Clark Swanson. Remember a year ago when we didn't know who Clark Swanson was? Can we go back that far in our brains and be like, who? Remember when we were all like, oh, Tati has a business partner. Cool. And then to get into, the Duggar stuff is heavy. So there's not a lot of making fun of it. You just can't. But we're going to talk about the facts in the law as that thing runs up to trial. And I don't know why he thinks that this is a good idea, but apparently he's like, what we're going to do is just roll with it. I wouldn't make that choice, but we're going to talk about what I think when we get to it. So let us eat, drink, and be merry and talk about law nerd shit. We're doing some real law nerd shit over here tonight. That's what we're doing. Real law nerd shit.
Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery.
We are here. So everybody, if it's your first time on one of our live streams, go ahead and put a 1 in the chat. I will always take the compliments. Thank you. It's gotten so long. I don't know what to do with myself. It's grown so much. And I love it. I just love it. I'm going to just keep letting it grow. And we're going to see how long it gets. Sometimes it's up, sometimes it's down. Sometimes it's more purple, sometimes it's less purple. I can be no, well, we're not gonna sing TikTok memes. I mean, maybe sometimes we'll sing TikTok memes, but not tonight. So, Amy, thank you so much. Y'all are my people too. Look, I talk about it a lot. These are this community is the community where I want to hang out on the internet too. And I feel like, you know what? We made our own space to talk about real law nerd shit. And I love it so much. So if you are new to the chat, go ahead and put, gosh, law nerds, so many of you. Good to see you. Good to see all of you that are coming in from A, all over the world, and B, all of the new law nerds. You guys are like, can we talk Duggars? Yes. Yes, we're going to do Duggar first. Don't worry. Don't worry. But there's more tea in the Tati stuff. There's some tea in the Duggar stuff, but there's more tea in the Tati stuff. We're also going to drink whiskey. Did I pull my notes up before I started streaming? Negative. That's a big negative. Why? Because I popped onto Ricada's live stream and was like, I'm just going to hang out for a little bit. We're just going to chat for a minute and then we're going to move on. And then that's not what happened because look, when you see lawyers out together in the wild, it's what that's like. Having a drink, telling stories, laughing a lot. And that's one of the things that I love about LawTube is we don't always cover the same things. We don't cover things the same way. We don't do things the same way. We don't see things the same way, but we enjoy having the conversation. And that's just the best. So I'm going to do a very short weekly roundup and then we're going to get to Duggar. Weekly roundup. So, real quick, there's a lot of stuff going on with the Alec Baldwin Rust shooting. I covered it this week on the Emily show, but so much more has happened. And it looks like the husband of the woman who was shot by Alec Baldwin has hired a very prominent law firm to handle the wrongful death lawsuits that we all know are coming. Oh, this is making me crazy. My fan has to move. I can see it. It's making me crazy. So Helena Hutchins' husband has hired a very prominent law firm, Panish Shea Boyle it's Duwali, and I cannot pronounce this last name right, and it makes me feel terrible. Ravapundi, I think that is correct. But they are also a law firm that is involved in this Aliso Canyon gas leak that Tom Girardi's firm, Girardi Keese, had been involved in too. Isn't it funny how all of our little worlds circle back together? So they, the name partner confirmed to Law 360. I've seen this reported elsewhere, but you know I really like the reporters at Law 360 because a lot of them are also lawyers, that they have been hired to work with the husband Hutchins, but do not and have not commented further. They are very well known. They recently received a $21.5 million verdict in a motorcyclist crash. They are well respected, and we absolutely know that the wrongful death lawsuit is coming. That is a given. We will see what happens. I imagine there won't be a ton of fighting. Like, how can you fight that? It's a wrongful death. Like, it just is. It just is. It shouldn't have happened. So I think how much liability is what they're going to be talking about and how much the insurance company will pay. I don't think there's going to be a ton of questions with regard to wrongful death and wrongful death related lawsuits. In the Vanessa Bryant case, where she is suing LA County for members of LA County law enforcement and first responders taking personal photographs of the crash or the helicopter crash that killed Kobe Bryant and his daughter and others. That lawsuit is still carrying on. But what we talked about was the defendant, County of Los Angeles, my former employer, asking the court to compel Vanessa Bryant and the other plaintiffs to take medical examinations in the mental health regard, because part of the claims in that case is mental anguish and suffering. And they're like, force them to take these psychological examinations, psychiatric examinations. And the court has denied that they are disinclined to acquiesce to the county's request in that regard. But 2 of those cases have also recently settled, and those settlements were approved by the County of Los Angeles Board of Supervisors in the millions of dollars range. I wonder if we will see a settlement with regard to Vanessa Bryant, but that has not happened yet. There has been settlement with regard to some of the plaintiffs, but not all of the plaintiffs. That is coming up not this week, but probably next week on the Emily Show, where we're going to do a breakdown of the different lawsuits. There's a wrongful death lawsuit, and then there's this County of Los Angeles lawsuit. I think that this will eventually settle. And now that the court has ruled against the county, I think the county has reason to settle. In another case that we've been covering, Netflix is lashing back at the Queen's Gambit lawsuit. I covered this a number of weeks back on the channel, and I am trying to circle back and give you guys updates without it going forever on the other cases we're covering, because we're covering not just Brittany housewives and YouTubers. We have other things that we're covering, but in that, the Netflix has responded to the Queen's Gambit slander lawsuit with an anti-slap motion saying this is protected First Amendment free speech. What we're not going to do is continue on. If you guys want a breakdown of that anti-slap suit, we can do it another night. We're not going to have time tonight. There is so much to cover, but it's interesting to see that we are in that anti-slap range again. That's also going on in the Triller H3, one of the Triller H3 cases with that anti-slap suit. So we will continue to see these come up. When I was a research attorney, anti-slap suits came up a lot. For those of you that are like, you're saying words that don't match my brain. Anti-slap is a motion that you can bring in California and other jurisdictions where they're alleging that a suit is a strategic litigation against public participation. Different states have different varying slap suits. They normally come up in the context of slander, libel, the defamation umbrella of stuff, saying, look, you're suing me to make me quiet. You're trying to chill my speech. Or if reporters are threatened with lawsuits or sued before reports come out, you individual are trying to chill my protected speech by suing me. You're using the court to make me shut the fuck up. And I have a right to not shut the fuck up. So the anti-slap litigation end routes all of the process of litigation, discovery, everything goes directly to they can't win on the merits. This is protected speech. Pay me my lawyer's fees and go fuck yourself. So that's essentially what Netflix is arguing in the Queen's Gambit suit. This is protected speech. We can say what we want. It's our show. This isn't slanderous. Literally just stop. You don't have to go home, but you can't stay here. So it'll be interesting to see what you think. If you haven't watched that video on the Queen's Gambit suit, I would love for you to go check it out and then let me know what you think about that lawsuit. Because it was really on the line for me. And for a lot of you, you were like, really? Is that really really? Like all of us that have been covering the suits on this channel have heard way worse defamation. So all of you were like, wait, that's what you're mad about? Like, I get it, but also I don't know if that's where we're going with defamation. So, I'm just going to put a plug. We have over 4,000 law nerds in here at 13 minutes in. Go ahead and do the YouTube things like subscribe, all that. I will let you know that if you want to join the Patreon and get the members only exclusive, you can absolutely do that. Law Nerds Unite. It will be down in the description below. I always forget to mention it. Once we get into these suits, I'm literally not going to talk about anything else. So that's what it is. Kristen Houston said it exactly right. Don't go away mad. Just go away. Anti-slap. That's exactly what it is. So let me make sure I've got the government motions pulled up first. With regard to the Duggar motions, we're going to go through the government motions and then the defense motions. There's like 10 of them. We're not going line by line. We're going to do an overview of them and of each of them. And then we're going to go through the Washington Tati case. We've covered the Nevada case a bit. The Washington case is Clark Swanson suing Tati, and Tati and James now suing Clark Swanson with counterclaims or cross claims in that complaint. with a lot of information about stuff that was going on in the workplace that we don't love. So, okay, as we get into Duggar, I'm going to remind all of you, we are law nerds. So what we're not going to do is disparage, name call, wish ill either Duggar, look, the behavior we don't love, clearly, and is illegal. And I think it's stupid that he's going to trial, but we're not going to name call. We're not going to disparage. We're not going to wish harm on him or on creators that cover him. There is room on the internet for everyone. Let us stay focused on what we're talking about. The allegations are terrible enough. And there are facts in here that are graphic. So just be forewarned. You know that you know what he's charged with. And if you don't, we'll go over it. These facts are graphic. We're adults here. The shit's illegal. We're going to cover it. For those of you that are new, I'm a former prosecutor. I will always tell you what I think from a prosecutor's perspective and what I think the defense can do and has done well. I think the defense has actually done a lot of things well in this Duggar case. I don't think it's going to help. I mean, the facts, I believe, are squarely against him, and we're going to see even more of those facts right now. Swoop. Let's talk about Duggar. All right, let's pull this up. This is how we do it over here. We pull up the cases together, normally before the show starts, but sometimes not because, ADHD and planning. And I don't, for those of you that are new, I don't joke about being ADHD. I am ADHD. I will miss lines. I will say things wrong. That's what part of why I pulled the documents up, so you can see what we're talking about too. So you can be like, no, Emily, no, that doesn't say $20,000. That says $20 million, girl. Get it right. So that's part of the reason. We're going to go through all of the government's motions in limine. I should tell you what that means first. Probably that would be helpful. Whiskey, we're going to get more clear as the night goes on because lawyering while intoxicated is always fun, and it's Friday. Motions in limine are the pre-trial motions where they sort stuff out. If you guys are watching the trials going on right now with either Ahmaud Arbery or with Kyle Rittenhouse, some of the things are handled before the trial starts. Some of the things are handled on the fly. In this case, the court has already made a bunch of rulings with regard to evidence and the defense's evidentiary objections. These motions in limine are really hammering down what will and will not happen in trial. Federal trials are very, very determined before they start, what witnesses can say and can't say. And so the government is like, here are our motions that we want to discuss about things for the trial, mostly evidence. And the defense is saying the same thing. Here are our motions. We don't want the government to do this. We don't want the defense to do this. And that is what motions in limine are. This is getting ready to go to trial November 30th. For me, it's really showing that Duggar is like, we fighting this, we doing this, it's on. And I don't know why that's the choice, but I don't know why that's the choice. I don't understand, but we're just gonna go with it. All right. First motion in limine is docket number 65. Motion in limine concerning trademark inscriptions. As I was going to say trademark inspections. No, trademark inscriptions. This is regarding the HP computer that was found in the office with the items of, and I will call them both CP because the actual charge is that, but also CSAM because that is really the proper description of the materials. I will switch between the two because the name of the charge is CP, but the items, the visuals, the things, the illegal shit, let's go with that. The illegal shit was on an HP desktop computer, and they don't want to have to establish foundation that it's an HP desktop computer. They want to just be able to say, look, see this logo? See this logo right here? This is an iPhone. Please don't make me call someone from Apple to lay a foundation that that's an iPhone because it just is. And particularly when we have trademarks marked on a device, there's no need to lay the foundation and bring somebody from HP to say, yep, that there sure is an HP computer. So this is just allowing them to refer to it as an HP computer because it is marked as an HP computer without having to lay the foundation for all of it and lay the foundation that it's an HP computer. So the trademark inscriptions, the government intends to introduce the HP desktop computer via HSI computer forensic analyst Marshall Kennedy. Like, if you're going to be a cop, the name Marshall Kennedy sounds like something from Paw Patrol, but I'm kind of here for it. So let's just keep. Marshall Kennedy extracted the data, including the CP from the device. The government maintains that the trade inscription contained on the device provides evidence that the device was manufactured outside the state of Arkansas and is admissible without any extrinsic proof. You don't have to say, yes, I'm proving it's a computer. I'm proving it's an HP computer. This is not unusual. This is literally just going through and crossing your T's and dotting your I's and pointing out the rules of federal evidence that allow it. I don't imagine the defense would object to this because that would be dumb. Like, this is not what you fight over. The computer's a computer, and computers are allowed to be introduced without arguing the fact that the computer is actually a computer. That is literally all that's in that motion. But what you don't want to do is not bring it up and have the defense bring it up. And the court goes, well, government, if you intended to introduce this way, why didn't you bring it in a motion? So this is part of lawyering. If you saw me on Mercatus stream a few days ago, we were talking about foundation and laying foundation. Laying foundation can be tedious and long, and it bores the shit out of a jury, but you have to establish the thing is the thing and prove it to the court. You can't just say, well, obviously it says HP, it's an HP. You have to prove it because you're admitting it in evidence. Hopefully that helps. We're not doing a whole lesson in evidence because we'd be here forever. Like, evidence, foundations, and rules of evidence in criminal law are most of what you focus on in practice. Like, the facts are one thing, but the rules of evidence are the thing you need the greatest grasp of. The government's motion to admit prior statements made by defendant. This is very interesting. If you remember my coverage from the other motions that the defense brought to suppress statements, then you will remember that the court did not suppress any statements, but this is just, hey, we're admitting prior statements. Prior statements are not the statements made in the interviews with officers. They are made before this arrest and before this case came up. And if you guys follow the Duggars, I'm sure you can guess at what some of those are. And yes, you're right, and we're going to get into it. The government would like a pretrial ruling deeming admissible certain prior statements made by the defendant regarding an addiction to online porn. The defendant, Josh Duggar, is charged in the 2-count indictment, we know. At trial, the government wants to introduce statements made by the defendant in which he admitted to having an online porn addiction. The government maintains that said statements are admissible as non-hearsay. We're not getting into all the hearsay rules. We'll just get into a little bit of it today, but hearsay is a thing. You generally cannot admit hearsay evidence into court, but then there's a whole bunch of exceptions to the hearsay rule where it's not hearsay, and it's not hearsay because of one of the exceptions. So like, this would be hearsay, but then because of these exceptions, it's not hearsay and it's used for a proper purpose. We're like, the law students are like, oh God, do we ever know? Do we ever know? The government maintains that the statements are non-hearsay admissions of a party opponent, meaning the other side, prior wrongful conduct intrinsic to the offense at issue, which is what we will talk about, or alternatively, as evidence of intent, identity, knowledge, and motive pursuant to the FRE 404B. So we're going to get into propensity evidence. Generally, you can't bring propensity evidence, but in some circumstances you can. So we're looking at the rule and then exceptions to the rule. And they're saying specifically in 2015, defendant publicly admitted via a post to his family's social media account that, quote, I have been the biggest hypocrite ever. While espousing faith and family values, I have secretly, over the last several years, began viewing pornography on the internet, and this has become an addiction. The defendant subsequently admitted his addiction to internet pornography to numerous witnesses. The government intends to call it trial. So they're not just seeking to admit a statement on an Instagram account or a website. They're seeking to bring in witnesses who are going to say, yes, this is something that I have had a conversation with Duggar about, and he has shared with me. It should be noted that the defense brings a motion to block this. So we're going to see both sides of this when we get to the defense side on this particular motion. The government anticipates that the facts produced at trial will reflect that the defendant had a program titled Covenant Eyes installed on his devices seized by law enforcement, including the desktop computer, the HP, his personal laptop, his cell phone, and all of those are as a result of the self-professed addiction to online pornography. So the government's not even getting into the Ashley Madison stuff. They are getting into Covenant Eyes being on the computer and the fact that Covenant Eyes is on the computer because he said he had an addiction to the porn. So Covenant Eyes is meant to guard that. I mean, these jurors, I had never heard of Covenant Eyes, and I'm sure these jurors are going to be like, wait, I'm sorry, what? Or maybe they know. I don't know. This was not something I knew, but we're going to continue on. Covenant Eyes is a program and service advised as an internet accountability software geared specifically to help individuals live porn-free with confidence. The overall service monitors internet activity and then relays that activity to a accountability partner. They went ahead and subpoenaed all of the information in the records, and the accountability partner was shockingly his wife. We learned this in the detention hearing that happened in May? With respect to the HP computer, the forensic examination of the device revealed that just prior to downloading, and this is new information that we haven't seen anywhere, just prior to downloading the CSAM, the CP, the images, the illegal shit, the illegal images, the defendant installed a Linux partition on the device. Not hard to do, to partition a device. Notably, the partition was installed on May 13th, 2019. On that same day, the Tor, which is the Onion Router browser, which is a means of accessing the dark web, was downloaded onto the Linux partition. So they partitioned the computer with Linux, which is another type of operating software, and then put Tor on Linux. The following day, May 14th, the Tor browser was utilized to access the CSAM. So the timing is get the computer locked down where we can access the dark web and then go get what we're looking for on the dark web. The following day, May 14th, the Tor browser utilized to access the CSAM. Shortly thereafter, the peer-to-peer program uTorrent was separately installed on Linux and utilized to download CSAM. So the illegal shit was downloaded on those 2 days on that one day using that partition. As part of the investigation, the government reached out to Covenant Eyes. Covenant Eyes is like, yeah, we're not compatible with Linux. So anything that's done on that partition, we're not going to be able to relay back because we can't see what's in that partitioned part of the computer. The government observes that an addiction to pornography is not a recognized disorder within the APAD and within the DSM. So it's not a diagnosable mental health disorder or a diagnosable addiction in the common vernacular of physical addictions. Therefore, a publicly stated addiction to porn is akin to a statement of habit as opposed to a prior bad act, crime, or wrongful conduct because, adult porn is legal. So that's not the problem. Under these circumstances, defendants' public and often repeated statements regarding the porn addiction are simply admissions that further identify him as a user of the computer when the CSAM was downloaded. So they're seeking to admit this information, not to show he has a porn addiction, but to show that he's more likely to be the one that installed the Linux partition. Because in this kind of case, you have to prove who's sitting at the keyboard, and you have to do that through circumstantial evidence because you don't have video of the person sitting at the keyboard doing the shit. So saying, look, This Covenant Eyes program is on the computer. The reason it's on the computer is because of all of this. This happened to Josh Duggar, not to anyone else. So who is the one downloading this Tor browser and this Linux partition on this computer to get around the Covenant Eyes? Who would that be? So they're using it to show identity, that he was the one behind the keyboard because of what he has previously said publicly. They go on to argue, alternatively, this is res geste evidence, which means it's evidence that makes a complete picture. So, hey, we're going to explain why Covenant Eyes are on this computer and why it's been partitioned, but that doesn't make sense if we don't talk about the public statements that were made. So we have to talk about the public statements, not to say like, oh no, he's a bad dude for liking adult pornography, but to say this is why the computer is his. So hopefully that makes sense as we move on. So there's two arguments under essentially 404 in case law as to why this, with regard to the addiction, should be allowed in. They go on to say that this provides context, that it that the government would be required to present evidence to a jury that a computer program designed to help an individual overcome a pornography addiction with the assistance of the individual's friends, family, and their church had been installed on a work computer without any explanation of who installed it and why. This is a relatively bizarre scenario. No, this relatively bizarre. Why can't we say bizarre tonight? Whiskey. This relatively bizarre scenario becomes perfectly sensible and understandable, however, when the required context that the program was installed by or at the direction of the defendant and his wife, because the defendant publicly admitted to having an addiction to online porn. So then it makes everything make sense. It's like, make it make sense. Okay, this is the context. So then they get into 404B, which generally bars admissions of crimes or bad acts to be used as character evidence. It's like, look, they did this, that's why they're bad. You can't do that in most circumstances, but the rule of inclusion means you can bring it for other permissible purposes like these, like the context, like the completion, and it's also not illegal. So they're not showing a bad act or a crime, because generally it's not a bad act or a crime. It goes to identity and it goes to completing the evidence and making it all make sense together, because things don't happen in a vacuum. So that was two of them. Let's go to the next government motion in limine to exclude third-party guilt evidence. This one's really quick. We're not going to get into it much. Here's the thing with this. They're saying, and they filed a motion previously, hey, if you're going to give us the Saudi defense, some other dude did it. If you're going to give us a some other dude did it defense, you have to prove why you think some other dude did it. You can't just say anybody could have walked by and tapped on the computer and just, I don't know how that happened. You can't do that. You have to show that there is a connection to some other dude did it, right? And so the government is arguing you cannot bring in unsubstantiated third-party guilt evidence at trial. So if you're going to do that, you have to prove why there's a connection between the some other dude, and that's, how we refer to it in law school. Dudes can be ladies. Look, I'm from California. Dude is gender neutral. Some other dude did it, or you can't allude to it. Your attorneys can't be like, anyone can access a computer. At trial, the government anticipates the defendant will attempt to introduce evidence suggesting that other individuals had access to the HP desktop computer. We'll get to that in a minute. And therefore could have committed the offenses charged in the indictment. That is the shade. I appreciate both the parties in this case, the government and the defense. They've had moments of shade and cheekiness, but their writing has been so clear and so concise, and in IRAC form, it's just a pleasure to go through it and just be like, this is the issue, this is the law, this is the argument, here is the conclusion and what we're asking to do. It's really just a pleasure, because so much of what we cover on this channel is just a shit show. I really love getting to go through well done legal documents. So thank you to everyone. The single, the double spacing, the easy headers. It's well done work on all sides. So just cheers to the simple things in life. So the government anticipates they're going to bring in some Saudi defense and says any such evidence is nothing more than wishful speculation based on bare suspicion, which is inadmissible under the legal precedent cited herein. Facts. On August 20th, 2021, the defendant filed a motion. So this is now using what the defendant has already done and saying, Your Honor, we believe they're doing this because they've already said this, which whenever you can use the other party's words against them, it's going to work well. And when you can use the judge's words to your favor, Your Honor, you said this, remember? So wise, so smart. Thank you, Your Honor. So clever. Do this again. Using the other party's words against you or against them always has great effect and is one of my favorite things to see done and to do. Well, used to do, could do, Mike could do. August 20th, defendant filed a motion entitled Defendant's Motion to Dismiss for Government's Failure to Preserve Potentially Exculpatory Evidence. I covered those motions on the playlist. They're talking about individuals who had access to wholesale motors. They named the three individuals, William. This is confusing to me because it's William Mays, Joshua Williams, too many Williams already for me, and Randall Berry. So witness 1, 2, and 3. On September 27th, this honorable court, so smart. Thank you, Your Honor. This honorable court conducted the hearings with regard to the collective motions. At the outset of the hearing, counsel for defendant moved to withdraw their argument on the motion to dismiss with respect to witness number 2, Joshua Williams, which is also information we didn't know. Specifically, the government brought certain information to his attention. The government brought certain information to his attention. I imagine that was an email going, oh, by the way, did you know that? And then this is the did you know that? Specifically, after the government brought certain information to his attention, defense counsel advised the court that he realized that he and one of the defendant's other attorneys had actually represented Mr. Williams. Oh, just forgot, had represented Mr. Williams in April 2019 in connection with a criminal matter that resulted in Mr. Williams being sentenced by a Benton County Circuit Court judge to serve 45 days in county jail. Further, the government provided the defense jail records confirming that Mr. Williams was in custody from April 15th, 2019 to May 28th, 2019. Ergo, he cannot be at the car light. He cannot be on the computer. He was in jail. So there's no way he's the other dude that did it. So we're not even talking about him. Irrelevant. Then they say during the hearing, the government also presented evidence that per the wholesale motor car sworn records. So the business records, this will come up when we get to the defense motion. The business records sworn to and produced by the defendant, no other employee worked at or were paid by Wholesale Motors during the time frame of the charged conduct. There were no other employees during this time in May. And they show that the first dude, Matthew, worked at Wholesale Motors until the end of April. And the other dude, Randall, didn't start working there until later in May. He worked May 24th to May 31st and got his first paycheck on May 31st. So during the time frame in question, there was no one else at the car lot, which also makes logical sense. If you're doing allegedly shady shit on your computer, would you do that with other people around? No. It just, logic. You watch your porn in private, I mean, or with a partner. I don't think that's happening in this case. Also, this is illegal porn, not legal porn. So, we're not going to go down that tangent, but you know what I mean? No one else was working there. So no one else is just using the work computer. And we don't have any evidence that somebody just strolled in off the street who had knowledge of the dark web. After the hearing, federal law enforcement contacted Mr. Berry, who confirmed that he did not start working at Wholesale Motors until the end of May 2019. I imagine that he will come in as a witness saying, I didn't work there then. Okay. I didn't work there then. He also informed law enforcement that after the execution of the search warrant at issue, the defendant closed his car dealership. I didn't know that. I'm sure y'all did. I didn't know that. But assisted him in getting a job at the defendant's brother's car lot. Who knew his brother had a car lot? Y'all knew. Tell me in the chat if you knew. I didn't know. I had no idea. Where he still works to this day. This information has been provided to the defense in discovery. Additionally, law enforcement determined that on the morning of May 15th, Mr. Mays, who was never an employee at Wholesale Motors, was in a Walmart located in Ozark, Missouri, approximately 120 miles away from Wholesale Motors. This information has likewise been provided to the defense. How did you know that dude was at Walmart? I mean, they must have pulled like his credit card records or Walmart security footage, but they were like, no, we're not getting there. He was at Walmart in Ozark, Missouri. Like he was not in Arkansas doing this. On or about October 5th, the government filed a motion requesting that the defendant provide notice of an alibi defense. The defense hasn't. The government is likewise aware that the defendant has made statements. I had not heard this. Please let me tell me if you've heard this and in what context, because I did not know. The government is aware that defendant Duggar has made statements to potential witnesses that his current legal situation arose because he placed too much trust in felons or ex-convicts. What? You're trying to blame somebody else, boo. That's not going to work. And if they're watching any of the coverage of this, they're going to see that you said that. So that's not going to go well for the witnesses. So I don't know what context that happened in, but the witnesses have told the government that he's in this situation because he placed too much trust in ex-convicts, which gives me a lot of insight into what's going on and why this case hasn't pled. He doesn't think it's him, or at least he's going to try to convince everybody that it's not him because I'm in this situation because I trusted felons and ex-convicts. Those felons and ex-convicts weren't at the car lot on that day, and you're not going to be able to prove that they were. Your phone... In the detention hearing, we heard that his phone was pinging at the car lot this day. The jury is going to hear that Duggar's phone and the photos on his phone are stamped at the car lot during the same time frame that this happened, and that the password for the partition on the computer included his birth date and was the same one he uses on his bank account. If you're working with felons and ex-convicts, are you giving them your password that includes the password to your bank account? Fuck no. The government's going to have so much fun trying to argue this without saying who the fuck would give felons and ex-convicts the password to their bank. Who? And one of them was in jail and one of them was at Walmart and the other one didn't work there yet. And you trust him so much that he's working for your brother. So, yep. Then they go into the case law. I agree with them on this. They go into the case law that says you have to show a nexus. You have to like prove it. Based on the above, the defendant should be prohibited from advancing evidence of third-party guilt. They're not going to be allowed to argue it. It'll be interesting to see what the court does. I think they will grant this motion. And then the government puts it simply for us. Put simply, the mere fact that these three individuals may have been present on the car lot prior to execution of the search warrant, but outside the time frame at issue, when the illegal shit got on the computer, is wholly insufficient to permit the defendant to advance a theory of third-party guilt with respect to any of them. In fact, their presence at the car lot outside the time frame at issue in the indictment places them in the same category as any customer who visited the car lot at any point in 2019 or beyond. Are you going to say your customers did it? They just wandered into your work computer and knew your password to get on your partition that you installed? All right. Next motion in limine. Government's notice pursuant. Okay, look. We are getting into the prior accusations of shit that went down with other minors. This has details in it. We are going to go through it. I am giving you the warning now. If you are familiar with the Duggar case, you know the accusations that he admitted to with regard to his sisters and the molestation therein. If you need to opt out, I will see you in like 15 minutes. Set a timer, come on back. That's what we're going to talk about right now. So that is my warning, because I respect that a lot of people have experience, sadly, with sexual assault, sexual abuse, and molestation in their sphere, in their life, or with themselves. And this information can be a bit too much. I feel like I've gone on long enough to give sufficient warning that that's what's coming up. Thank you, law nerds, for being kind to each other. And thank you. You do not need to, if that is your experience, you do not feel the need to share. Just we're going to take a breath. We're going to put on some chapstick, and we're going to just move on. All right. You ready? The government is just like, oh, you want to play? Okay, here's the evidence we have against you. Have fun, buddy. Government's notice pursuant to Federal Rule of Evidence 414 and motion in limine to admit evidence of the defendant's prior child molestation conduct. This is propensity evidence. In very limited circumstances can you use propensity evidence showing, look, because they did this thing, they're more likely to do this thing. This is not a guaranteed slam dunk for the prosecution. This is not a molestation case. This is not a hands-on case. This is a CP case. So the court might not. I think they will, but the court might not. Let's get into it. We know the background. We know what he's charged with. We know the jury trial is beginning November 30th. In light, let's see. Where is it? At jury trial, a jury trial is scheduled to begin, in this case, November 30th. The government anticipates that the defendant will attempt to argue at trial that he was not the individual who used the HP desktop computer to download and view CSAM, and is not interested in such material. So they're thinking, look, they're anticipating Duggar's going to say, or his defense team's going to say, hey, I never seen it, don't want to see it, didn't do it, some other dude did it, I didn't do it for the computer, blah, 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 blah. That's the defense they're anticipating. This has to become relevant before it's admitted. This does not just go to the jury to just go to the jury. It has to be relevant and probative, and not more prejudicial than probative. Probative meaning helpful to the jury, prejudicial meaning, well, if you did that, you probably did this. That's like, yeah. So this has to become relevant. This is a stick that the government is using. Hey, if you argue that, we are going to use this. So this doesn't come up unless the door gets opened generally. So let's get into what the government says. In light of this anticipated defense, I'm not interested in the illegal images shit, and I didn't even use the computer. Pursuant to FRE 414 and 404B, the government now provides the defendant with notice, you're on notice, that it may seek to introduce evidence at trial that the defendant committed other acts of child molestation as the term is defined by Rule 414. Specifically, the government intends to introduce evidence that in 2002 and 2003, before he committed the offenses charged here, while living in Arkansas, the defendant attempted to and did commit the crime as defended by Arkansas state law, involving contact between any part of the defendant's body and a child's genital or anus, namely sexual assault in the second degree, codified by Arkansas Code Annotated 5-14-125. If introduced, the government anticipates that the evidence will consist of testimony, live testimony, that's a person testifying, that the defendant was investigated for, admitted to, and received counseling for touching and sexually molesting multiple minor females. including at least one instance involving the digital penetration of a prepubescent minor. That is a young minor. That is a very specific crime. The reason they listed it out this way is because that is a very specific crime. So they are not listing it to be salacious. They are listing it to say that act is a specific crime, and he was investigated for not just touching, but also for the digital pen of a prepubescent minor. That means in most states under the age of 10 or 11. Some states it's, I think, 9. So, yep. So that, which I don't know. For those of you who follow the Duggars much more closely than I do, because I don't know if that's new evidence or not. I know the stuff about his sisters has been out there. I know there were statements made. I know filming was going on and he did therapy. I don't know if all of the details have come out. I'm not going to dive into them anymore because it's not really relevant. So that's where we're at. Federal Rule of Evidence 414. Defendant's uncharged prior child molestation conduct is admissible in this case under FRE 414, enacted as part of the Violent Crime Control Law Enforcement Act of 1994. FRE 414 governs the admission of evidence of similar crimes of child sex offense cases. These are used in lots of these types of prosecution. My dearest friend only deals with child molestation prosecutions. We talk about 404B quite a lot. These are specific rules of evidence because of the nature of these types of prosecution. So these are rules of evidence saying, look, this evidence that might otherwise be inadmissible becomes admissible in these types of cases for specific reasons. And most of those are interest in public safety, especially when you're dealing with children who are dealing with testifying about trauma, especially that can happen with very young children. The propensity of 1 victim, 2 victim, 3 victim, 4 victim, even if they weren't all charged, can aid in the prosecution. And the government has said this, we would like to prosecute people who do this more, please. So that in a criminal case in which a defendant is accused of child molestation, the court may admit evidence that the defendant committed another child molestation. The evidence may be consistent, may be considered on any matter to which it is relevant. So they are arguing that the term molestation covers any conduct under 18 USC Chapter 110. These charges are covered by 18 USC Chapter 110. So it is not just hands-on, but it is also the viewing of the things. So that. And so they are saying that these charges fall under 18 USC Chapter 110. And because they do, that these prior acts can be used as propensity evidence if the door is opened and he says, it wasn't me. I'm not interested. I wasn't at the computer. They can say, well, you are more likely to have been at the computer because of all this other shit. An upshot of Rule 414 is that the evidence of a defendant's prior acts is presumptively is a big word in criminal prosecution. It means it's admissible unless you meet the hurdles to make it inadmissible. It comes in unless. And presumptions weighing in favor of the prosecution means this will likely come in. Presumptively admissible to establish the defendant's propensity to commit the charged offenses. They go on to say that in allowing this evidence, Rule 414 reflects Congress's view that this propensity evidence is typically relevant and probative. That goes to the rules of evidence. They go on to say, in the addition to the plain text of 414, legislative history shows that they intended the rule to be an exception to the ordinary bar on propensity evidence. This is all the normally you can't, but here you can. Here, both offenses charged in this case and the defendant's prior conduct that is the subject of the government's proposed evidence constitute child molestation as defined by the rule because it falls within Chapter 110 of Title 118. They go on to say, because of the arguments made by the defense so far, the government anticipates that the defendant intends to claim at trial that someone else used his computer, because that's literally what all the defendants say. It's like in drug cases where they're like, those weren't my pants. Someone else wore my pants. It is just one of those things that is a standard defense to these cases. Someone else used a computer to download and view the material depicting minor girls engaged in sexually explicit conduct, and that he's not interested in such material. As the Eighth Circuit explained in similar cases, evidence of the defendant's molestation and sexual interest in minor girls, including in this case, girls in the approximate age ranges of the victims, depicted in the CSAM in the illegal shit the defendant downloaded or attempted to download from the internet is highly probative of the defendant's knowing receipt, which is what's charged, and possession of CP on his computer. The case law leans this way, saying, yes, these are all under the same code section. Yes, they are admissible. Yes, they're admissible under 404B. They go on to say this will show the defendant's motive, intent, knowledge, and lack of mistake. This is what you were looking for, and this is why. They go on to evaluate it under Rule 403 of the Evidence Code, which for our purposes is not needed, but I appreciate how well they went through 403. The government has done a good job here. They go into the relevance to show that the defendant received and possessed the charged CP. By pleading not guilty, the defendant has placed his knowledge and intent at issue in the case, thereby rendering any evidence of similar prior conduct especially relevant under 404B, but not unfairly prejudicial. So what they will do when they argue this in court is argue when it's relevant to come in at trial. Is it not relevant until he says, yeah, but somebody else used it? Or does it become relevant sooner to that in the prosecutor's case in chief? And the court will decide that and say it is relevant if they open the door, or it is relevant in the case in chief. If it becomes relevant in the case in chief, which is likely, I don't know how Duggar overcomes that with any defense. I just don't. It's highly probative, but it can be highly prejudicial, and you can use highly prejudicial evidence in this circumstance because it's more probative than prejudicial. I sound like my 1L teacher, and I'm living for it. That is the end of the government's motions. Cheers, y'all. We got through the government's motions. Now we're going to Duggar's defense motions. There aren't that many, and then we're moving on to Tati Westbrook and questions. So everybody take a breath. The defense motions are not as detailed, and we will move on to them. Also, did you all see the new Starbucks cups? In this last week, I've gotten 3. The jeweled, this gorgeous rose gold piece of peace. My Halloween scary cat that I found late in Atlanta that glows in the dark, and the cat is glittery. And this color changes like I'm back in the 90s, like when it gets cold, it color changes. And it is the Starbucks siren. Yes, she's a siren, not a mermaid. Yes, she has the split tail. And I have 3 cups of water on my desk right now. This is how we do it. We need all the water, and the humidifier is going so my voice doesn't get dry, because that's what's been going on lately. So Stacy said, I'm waiting for your son T to come in and lay shade on your cups. I've been hearing it for 2 days. He's like, Mom, one in, one out. And I'm like, no, they're now, there's a museum of cups now. It's a collection, and I love them, and they are mine. So we all needed a breath, right? We were all like, let us move on to the defense motions. And again, I think the defense is in a very difficult position in this case. And I think the lawyers have done a good job with what they have. I think that they have handled their motions really well, and they are well done and well written. I imagine his defense is costing quite a bit of money, but they have done a good job with what they've got. But there's not much they can do about these facts. We've heard about the facts. They can't do anything about the facts. They have to try to limit what the jury hears as much as they can, and they're not going to get very far on that. Sarah F is like, is it good to come back? Yes. Welcome back. We're swooping into the defense motions. We're clear of what we were talking about. It will come up again. I will mention when it does. Defendant's motions in the Josh Duggar case. The first one is defendant's motion in limine to prohibit the government from attributing the act of producing corporate records to Duggar. This is an interesting one for me, but I said, remember, they're going to talk about the records. The records are going to go to the employees that didn't work at the car lot during the relevant time. Those records were produced by Josh Duggar. He is the one who's in charge of the records. He produced them subject to subpoena. They are saying that that goes against his rights, and they're saying that Duggar was not summoned or subpoenaed in an individual capacity. He was summoned as the corporate's record custodian of the car lot. Therefore, the government can't say the act of production of the corporate records showing that people didn't work at the car lot was Duggar. They can't say, well, he gave us these records. I don't know how the court's going to parse this, because you have to lay a foundation of where the records came from, and you have to show that the records were gotten by subpoena, that they came from a record holder, but they can't make Josh Duggar testify because he's the defendant. So they will probably stipulate to the authenticity of these documents and just not even worry about it. It's been stipulated that these are the official records of the company and move on, but they brought it up. So they brought it up. I'm sure they'll just stipulate to the records being authentic. Defendant's motion to exclude improper opinion testimony. I think they're right on this. I think the court will grant this unless they open the door, because once defense opens the door, then the government can say, Your Honor, we need to hear a motion on this. It needs to come up. But this is stuff that came up in the detention hearing back in May. So they are saying, at the detention hearing in this matter, the prosecution elicited testimony from Special Agent Gerald Faulkner about a specific torrent file. The agent testified, and this, I remember talking about this when I covered that hearing. And the quote is, and I can say in the 11 years of doing this and the thousands and thousands of CP images and videos I've unfortunately had to see, the Daisy's Destruction series, which, side note, was recovered from the computer. The Daisy's Destruction series ranks in the top 5 of the worst that I've ever had to examine. Now, at a detention hearing, this is relevant. At a detention hearing, you're telling the court, look, this is really fucked up shit. Also, if you're curious, do not Google this. Just trust me. You can't unlearn. Do not know. You don't want to know. You don't want to know. Trust the agent that's done this for 11 years saying that this is the worst, and just don't go there. Trust me, and you're welcome. But at a detention hearing, it's giving the court scope and context. At trial, it can be very, very prejudicial, and this might not come up. So I agree with the defense. It's improper opinion testimony. It's not relevant, and it shouldn't come up unless they open the door. So I think that the defense will have this motion granted. I don't think the government would seek to introduce that. It's out of context in a trial. It's perfectly relevant at a detention hearing. Chelsea said, I Googled it and I can attest to the inability to you can't unknow. There's some things you don't need to know. You just don't need to know. You just don't need to know. I'm just. So they go into the legal of why, and that it's opinion testimony, that it's completely irrelevant. I agree that it's irrelevant. And I don't think that there would be a context where it comes up. And I think the defense will be careful enough to not accidentally bring it up. Let's talk about Ashley Madison again. Because defendant's motion in limine to exclude evidence of allegations concerning adultery or a prior so-called, quote, addiction to adult pornography. Look, it's like Erica Jane saying it's alleged. He said the words addiction. Those were his words. Don't quote me. Don't come at me with like so-called addiction. He said it. Alleged addiction. Lord. All right. In 2015, there was media coverage concerning a hack of the Ashley Madison website, which purported to cater. It didn't purport, that's what it did. Purported to cater to consenting adults seeking to engage in extramarital affairs. Do we all remember this? I remember this. I was like, wait, what? I'm not surprised they got hacked. They were ripe to getting hacked. People wanted to see what politicians and celebrities were on there. Also, if you're signing up for websites like that, don't use your name. What are you doing? Like, I don't think Duggar's clever. I don't. I think he's tries to be clever, but I don't think he's clever. According to media accounts of the hack of the website, Duggar was revealed as a subscriber. Duggar and his family were, at that time, television personalities. In an effort to minimize the public relations fallout from the embarrassing revelation that Duggar was allegedly a member of the website, the Duggar family issued a press statement on the Duggar family website. It's interesting because they are saying that he didn't say it. They go on to say the statement attributed to Duggar included. So there's an argument that this is not an admission by a party opponent, the defendant, because the statement is attributed to him. They are very careful not to admit that Duggar made this out of court statement, which is smart. And I'm not mad at them for it. Good job, defense counsel. And it included, quote, while espousing faith and family values, I have secretly over the last several years been viewing pornography on the internet, and this has become a secret addiction, and I have become unfaithful to my wife. What's interesting is that the government has said that this is not the statement they're relying on. They have witnesses that have spoken to Duggar. So the witnesses are going to come in and be like, he told me that. So we don't really need this online statement. Fine. Take your online statement. We don't give a shit about Ashley Madison. We'll just ask the witnesses because there will be people that will say it. They go on to say, discovery disclosed by the government in this case reveals that investigative agents inquired about such allegations from certain witnesses. And we've seen that in the government's motions too. They say whether Duggar allegedly characterized himself as being addicted to viewing adult porn or being unfaithful to his wife is irrelevant and therefore inadmissible under the Federal Rules of Evidence 401 and 402, which would be the case if they weren't using it to show why he had the things on the work computer he had and why it was partitioned. I'm not going to cover the Ashley Madison stuff. The government didn't bring it up, doesn't care. So I'm sure the court will be like, okay, government, you can't bring up the Ashley Madison stuff. And the government can go, cool, we're gonna. They say whether Duggar was a member for years of that site is irrelevant, sure. Whether a press statement attributed to Duggar a so-called addiction to viewing adult porn are not anyway relevant to whether he committed the crimes pending. Disagree. I agree with the government's position of that, but the Ashley Madison stuff won't come in. The next one is defendant's motion to exclude evidence of juvenile allegations. We are going to talk about these again. I'm going to swoop it because that'll be helpful for a timestamp. But we are going to talk about the allegations with his sisters again, not in as much detail, but we are going to talk about that again. So, same warning as before. It is brief in this context, but we are going to talk about it again real quickly. The defense is arguing that the government disclosed to Duggar a Springdale, Arkansas Police Department report dated December 7th, 2006 that was obtained from an entertainment tabloid publication. The report appears, this is what I learned from this. I learned how this information got out in the first place, and I thought that was very interesting. It was obtained from an entertainment tabloid publication. I don't know which one. Chat, you guys might know. I do not know. The report appears to memorialize an investigation, conduct of allegations. No, an investigation of allegations of sexual misconduct. Sorry, there's an extra word in there, and it absolutely stopped my brain from processing. Against Duggar while he was a juvenile. And that is going to be very interesting how the court addresses the fact that he was also a minor at the time that this took place as well. The report notes that the allegations were alleged to have occurred more than 3 years prior to the date that the report was drafted. Thus, the allegations are more than 18 years old and allegedly occurred while Duggar was a minor, though he admitted to it and then went to therapy. So They never led to any charges or convictions. Furthermore, it appears that the only reason this report is in the government's possession is because it was unlawfully leaked to the media several years ago. Specifically in May 2015, a law firm purporting, they're just going on with all of this as alleged. They're saying alleged more than Erica Girardi. A law firm purporting to represent a magazine filed a FOIA request, Freedom of Information Act request, seeking all files related to or mentioning Duggar. And somebody should have objected and not turned over things that related to juvenile cases, because juvenile cases should not become public. However, under Arkansas law, this was not permitted in Arkansas. Any data, records, reports, or documents that are created, collected, or compiled or any other entity with regards to children, individuals, or families shall not be subject to FOIA requests. And that's true in like all jurisdictions. So it shouldn't have been released, but that doesn't mean it won't. FOIA requests make mistakes. And so a law firm for a publication was like, hey, we suspect something's up and we're going to ask. And if you ask, you might receive. So it's not wrong on the publication to get it. It was wrong on the department to release it. They got it legally. They got it through a FOIA request. It should not have been released by the police. That's not the publication's fault. They go on to say, despite the fact that the indictment focuses on a 3-day period in May 2019, and focuses entirely on computer crimes, the government seeks to introduce allegations arising when Duggar was a teenager that have nothing to do with computer-based conduct. We know the government's theory because we already went over that. Moreover, the allegations at issue never led to criminal charges or convictions of any kind. And we've already heard the government's theory of that too. So they're saying it's not relevant and therefore inadmissible. The government's arguing it's relevant to show why the computer, to show why he was on the computer. And if he says, and the court might very well say, okay, fine. The government can't bring it in their case in chief. But if you try to prove or allude to the fact that he wasn't on the computer's not his, he's not interested in that, he has no reason to be interested in that, they can show, look, this shows more likely that he's doing these things. So they go under 404 B2, saying that the government has not provided notice that it intends to offer such evidence. They just provided notice. I believe that that's timely under the federal rules. Moreover, this type of evidence can only be admitted if it serves a purpose other than proving the defendant's character, such as motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, and lack of accident. And that's what they're going to say. Look, the reason he was looking for this is because this is what he's interested in. And they are arguing that that is not the case. Moving on to the next one, this is to sequester witnesses. I know sequester sounds like it's a whole big thing. Literally all this motion says is, hey, when a witness is testifying, other witnesses can't be in the courtroom and listen to it, which happens in all cases. They're not going to be able to keep out the lead investigators, the lead law enforcement officers. Sometimes defense attorneys try it. Like, the government can't, this officer is going to testify. He can't listen to the other testimony. He's already heard their testimony. He's the one that took all the reports. They did this. They're the investigating officers. You can't boot them out of the courtroom. This is just keeping the witnesses away from hearing other witness testimony. And normally the courts will grant this. It's proper to grant it. Witnesses shouldn't be listening to other witness testimony unless they already testified. And that might be what the government says is, fine, once a witness has testified and they are done, both parties have finished with a witness, then they're allowed to remain in the courtroom. And that's what most courts do. It'll be interesting to see how the court rules on this. It's nothing really of much note other than, yeah, that's the way that happens. So next, motion in limine to exclude any reference to defendant's stated decision declining to answer certain questions posed by law enforcement. So this would be defendant essentially raising his Fifth Amendment rights, going, I have the right to remain silent and I'm not answering that because I know better than to answer that. So we will absolutely be talking about it. Adam McIntyre, we're going to be getting to Tati stuff in just a minute. Good to see you. Hope France is lovely. Also, isn't it late? Also, I'm sorry that Nightbot is mad at you. We love you. where was I? I was getting into Adam's got such great new tattoos. Do you guys watch Adam? I love Adam's channel. We're gonna get all the Tati tea. We're getting there soon. We're finishing up with this last request of Josh Duggar not answering questions, and they're arguing that it's Fifth Amendment. Again, this can change if the defense opens the door for it. And this has already been denied in the motion to suppress. It's like, look, the statements he made to law enforcement aren't going to be suppressed. Generally, the prosecutor can't say things like, well, if he was innocent, wouldn't he have answered the question? Like, that's shit you can't do. That's against the Fifth Amendment. So it's the court making it very clear that the government can't make more out of it and shouldn't bring up the questions that elicited no response. The defendant's allowed to not respond, but this was a non-custodial interrogation, and the Fifth Amendment doesn't attach at a non-custodial interrogation. And I think that's the way the court will go, that this was a non-custodial interrogation. The court could also go with, look, don't bring it up unless the defense opens the door. We're going to see. I'm just going to go through the testimony because that's the most interesting part of this motion. Specifically during questioning Duggar, the following interactions relevant to this motion transpired. Agent Aycock. It's very hard for me to not make fun of that name because in the context of this case, it's totally inappropriate, but know that it's happening in my brain. Just know that. I just know that. Agent Aycock says, okay, so now what I'm going to ask you is, are you willing to speak to us without an attorney present? I mean, I may not answer everything, I guess, but yes, I don't think that questioning is a problem. He's allowed to say, I may not answer everything, but yes, I guess. Okay, all right. Josh Duggar, what is the scope as far as like how, answering some of these questions? I want to be truthful and upfront. Agent says, sure. Duggar says, or I just want to decline to answer, but I'm just curious as far as scope. Faulkner says, anytime you don't feel the need to answer it, yep, just let us know. Okay, exactly. The reason these are transcribed is because this was all recorded. Agent Aycock then says, can you tell me a little bit about your knowledge of electronic devices like torrent files, uTorrent, stuff like that? I'd rather not get into specifics on knowledge. All right, Jerry, do you have anything else as far as that goes? Agent Faulkner, I think we're probably going to get to that point now where Duggar says, yeah, okay, and I can't speak on your behalf. Yeah, that you're probably going to not answer too many more of our questions. Duggar says, no, I understand. They knew the direction that ship was sailing in, which then if that's the case, obviously without legal counsel, like let them finish what they're saying. Stop talking over each other. These little ellipses mean that people are interrupting. I had to transcribe a hostage situation when I was a law clerk, and it was so hard to transcribe people talking over each other. Just let them speak. Well, without legal counsel, I know, no, I don't want to. And here's the say something. And like I say, everything that I've already said, I'm going to say the best of my knowledge. I'm trying to be straightforward with you guys too. Absolutely. I'm trying to make that easier. Look, we appreciate that. Duggar, I just don't want to get into entrapment of any sort. Well, we've got your computer, bro. So, that's what that is. Faulkner, right? Absolutely. Duggar, and I'm not saying that, I don't want to say something that I just think of right now and then not honestly, not think about it. Faulkner says, now on you, but I've got to ask you directly, have you, and I'm going to ask whoever else is here that was around during the time, has there been any time on any electronic devices, intentionally or accidentally, where you've come across something of an inappropriate nature on the internet and possibly got rid of it? Well, I can't answer that question. Agent Faulkner, I've got to ask it. Duggar, yeah. Agent Faulkner, I've got to ask it. Duggar, at any time you say that's pretty broad. It is pretty broad. Have you ever come across inappropriate things on the internet? He's like, yes, I've been on Twitter. Josh Duggar, I don't want to get into blanket statements about anything, which is actually the smart thing to do. Agent Faulkner, I get you. He should have just said nothing. He was not obligated to say anything ever. Just, can we talk to you? No. You can do that. Can you give us a passcode for your phone? No. Sure can't. Nope. Nope, can't do that. Agent Faulkner, so has there been anything in the past that you or maybe you've seen someone else has been on their laptops and passing by that had inappropriate, by definition, CP images of children ranging between 5 and 10 years of age? Duggar, I'd rather not answer that question. Okay, that's perfectly fine. Agent Acock, that's your right. Agent, but see what they're doing in their questioning is they're giving him the ability to say, yeah, I fired this guy because he was doing this shit on my computer and I thought I deleted it and I can't believe it's still there and I was mortified and I didn't know what to do. But that's not what he said. So if Duggar says, well, I caught someone else doing this, they're going to say, we asked you about that. We asked that question. So it can become relevant in that way. Let's continue on with this conversation because these are things that we haven't seen before in legal documents in this case. So I'd rather not answer that question. That's your right, Agent Faulkner. Here's the thing about that phone. Oh, we binged. Y'all, we're going to take a break from this totally serious thing to celebrate the fact that we binged at 166K because you know it is my goal to push towards 200K by 2022. I'm ready for that to happen. So it binged. Let's celebrate. Like, cheers. We're going to keep drinking whiskey. Oh, it binged! Move your head! Ah! Yes, do we celebrate every time it bings? Yes, we do. Yes, we do. Let's continue because then, we're like an hour and 20 minutes in. I've had at least most of this and we still have to get to Tati stuff that's really juicy. So we're gonna zoom. All right. Here's the thing about the phone. And it's tricky. And again, this is completely up to you. They were very patient, the law enforcement. You know, federal agents were like, kind of whatever you want to do. It's fine. Whatever. Duggar, well, I can't. I can't give you access to it without talking to my attorney. Also smart. Agent Faulkner. Right. Agent Faulkner. Now, if you give the PIN, if you don't, that's fine. Duggar, I'll have to talk to my attorney first and then I can advise you. Yeah, don't do that. Look, talk to your lawyers. This is a smart answer. Just, it's frustrating for law enforcement, but it's a smart thing for you being investigated. Duggar says, if he says I can go ahead and then sure, I don't want to. I mean, there's a lot of, yeah, of course you don't want to give them the passcode to your phone. No, of course you don't. This is probably the only thing he did that was clever during this entire thing. Stated succinctly, many times during his questioning, Duggar expressly conveyed the agents that he was declining to answer certain questions. I think the court will rule that this can't come up unless Duggar opens the door. I mean, that's how that's going to go. And they go through and list the other times when Duggar says, I don't want to answer things without my attorney. That's fair to do. The government can try to argue, look, it's his Fifth Amendment right. I don't think the government needs that. I think he asked affirmative questions and the computer evidence is more damning. I don't think the government needs to push too hard. We'll see what they decide to do. And then we'll go from there. But it's time to move on to the Tati Westbrook case, and then we'll get to questions. I need to make sure I pull up the actual complaint because I haven't pulled that up yet. We haven't talked about the Swanson Westbrook case in Washington in quite a while. So we're going to do a brief road so far with all of the Tati cases because a year ago today, we were sitting here talking about Tati cases, I'm sure. Because all of them started popping off at like the end of October. And I think I started talking about it right around Halloween last year. And right at that time, the channel was at 5,000 subscribers. So welcome, law nerds. And for the 6,000 of you here now, just do the likey, subscribey things. We're going to get to questions in a minute. Let me pull up this very fucking long complaint. It's literally, when I say long, it's like 422 pages. When I tell you that the state of Washington charges 25 cents a page and it feels like a personal attack, it's because it does. Let's do a road so far. We're going to swoop. The Tati Westbrook legal cases started like a year ago with a case filed by Clark Swanson in a variety of ways, by him personally, by businesses, and derivatively against Tati Westbrook, Halo Beauty, Tati Beauty, and the businesses in California. That lawsuit is the one that not only was full of shade and talked about Jeffree Star and Manny MUA and Laura Lee and James Charles and Sugar Bear Hair, but it started with, say it with me, all of you that were here and remember, go ahead and put a 1 in the chat if you were here and remember our coverage of that suit. It started with,
this is a case because of the defendant's greed.
that was the opening. That was the opening of the lawsuit. And it was full of shade, full of shade. And so we covered that. All of you were like, yes, it's been a year of Tati lawsuits. That started in LA. That suit was recently, it hasn't been dismissed yet. It'll be dismissed in December, but the motion for form nonconvenience was granted. That case is supposed to be moving to Nevada. Then, so Swanson versus Westbrook, round 1, LA is moving to Nevada. Then Tati sued KJ in Washington. That settled. So that case is resolved, and it resolved with a video from KJ saying, look, I got this information from a source. That source is the business partner, Swanson. That dude told me the things. And it's still my belief that there are things that were said that were still in the realm of defamatory that were not said by Swanson, but it was more valuable to resolve that lawsuit to get the information about what Swanson had told her because of these other lawsuits than to nitpick over, yeah, well, these statements came before, because they're not going to get a bucket of money. They've got these other lawsuits to fight. They've essentially got bigger fish to fry. Then Swanson files a lawsuit against Tati and James Westbrook personally. Swanson is their business partner in Halo. He is a personal friend, I think we're safe to say was a personal friend of James Westbrook. They were all going to go into business together in Halo Beauty. He wants a piece of Tati Beauty. Tati Beauty is now a closed entity, which makes me sad. I really liked the Neutrals Volume 1. I thought it was clever. I liked the way that palette was laid out, and I thought the quality was great. But I digress. So Swanson sued Tati and James in Washington in June of 2021. Then Halo Beauty sued Swanson in Nevada over all the business shit. And we went through that with like, hey, you're a member of this company and you're feeding information to a YouTube drama channel to hurt the company and to hurt our reputation. Literally, what the fuck? And then the extra allegations. Do you remember the amended complaint? The amended complaint that Swanson put his fiance, baby mama's parents on the payroll of Halo Beauty without the authority of James and Tati, and was paying their health insurance. Now, James said it was okay. James said he didn't. That suit is still going on. So what we're covering today is the Washington suit between Clark Swanson and Tati and James Westbrook that made it personal over in Washington, and Tati's response that was just filed November 4th. Was that yesterday? When Tati closed Halo Beauty and announced it on social media, I was like, what's going on? What's going on? Hey, something's happening. So then I went and looked in Washington, and then I went and looked in Nevada, and then it was like, hey, they answered the Nevada case. The Washington case. A lot has happened in the Washington case. Procedurally, there was a default. The default was set aside. I'm not going to get into the nuts and bolts of it because for our purposes, it doesn't matter. We just want to talk about what it says. We want to know. So we're going to skim this one real quick as a brief history, because a lot of you are like, wait, I don't even remember the Swanson versus Tati case. You do, because that's the case I got a cease and desist with that is literally this fucking big. And then I was like, hey guys, look what showed up on my door. So we've talked about that. So now there are 2 active cases, but I think the California lawsuit is going to boom on over to Nevada. So there will be 3 active cases. This has cross complaints. So summary of the complaint. Everyone's mad at everybody. The operative facts: Swanson sued the Westbrooks for breach of their fiduciary duties to the business they own together, Halo Beauty, on October 2020 in California. Swanson alleges that they had a a business meeting in Marina del Rey on August 1st, 2017, and they agreed to change the ownerships of the company. The Westbrooks are saying that's not how that happened. So they line out the statements that were made at that business meeting. They allude to the fact that there's a transcript of it, which is attached in the 422 pages of this complaint. Some of those have come out in the first amended complaint, but this complaint is 422 pages long with exhibits. And this is really over that Swanson's beef is that we changed the ownership of Halo Beauty, the vitamin company, the nutraceuticals company. I've had too much whiskey to say that a lot, but it's a lot in the other suit. We changed the ownership. It was 50-50. Swanson owned 50, Tati and James owned 50. Then it shifted to a third, a third, a third. Tati and James are saying it shifted to a third, a third, a third because he didn't put in as much money. He wasn't doing the things we thought he was going to do, and this was what was equitable. Swanson is saying, I shifted from 50% to a third because Tati promised all of the Tati things, including Tati Beauty, the eyeshadow palette. So because she promised all of that, I agreed to step back. And they're saying, no, that's not how that happened. And this is just, they disagree on the fundamental facts of this case. And I don't see this resolving anytime soon. I do think Tati's been really upfront in talking about it. We have not seen, I mean, Swanson doesn't have a platform, Tati does, but we've seen him liking tweets and, sending cease and desists to me and talking to other drama channels. We've seen a little bit of that, not recently. This is just, ugh. They go on to talk about the August 28th, 2020 letters. Those were the settlement negotiations that were happening before the LA lawsuit was happening. Then they talk about, this is kind of Swanson's perspective. Again, this entire thing's in another video. The reason I'm scrolling through it is to get to the claims that are here. The Los Angeles lawsuit threatened to be the final nail in the coffin of Miss Westbrook's YouTube career. That'll come up. The Los Angeles lawsuit attracted the attention of various YouTube celebrity commentators, including E! Insider, Yahoo, MTV, Daily Mail, and dozens of other news outlets around the world. The media attention was overwhelmingly negative towards Miss Westbrook. Miss Westbrook's subscriber base went into a nosedive.
This is a lawsuit because of the defendant's greed.
Remember? And it was like, I could just sell whatever. Look, there was a lot of tea in that lawsuit. This reply to it alleges that it wasn't all true, but Mr. Charles responded to her accusations with what the YouTube community began to call the receipts. I think that this is a shout out to Peter Mon. Peter Mon, I think you got a lawsuit shout out. Oh, I missed a paragraph. Hold on. The lawsuit came at a time Miss Westbrook's reputation and career were already under severe pressure due to her defamatory statements. Interesting, they qualify them that way. Against competitor James Charles. That is worded very much the way that KJ's answer to the Westbrook defamation case was worded. Just 5 months prior, Miss Westbrook publicly accused Charles of sexual misconduct. Oh, hindsight. In a YouTube video titled By Sister. That video was viewed over 50 million times. Westbrook gained 4 million subscribers in the week following that video and boasted an all-time high of YouTube subscribers over 10 million as of May 2019. The YouTube community called it Dramageddon. False! The YouTube community called it Dramageddon 2. And then Carmageddon came next. Just facts. Dramageddon happened before that. Mr. Charles responded to her accusations with what the YouTube community began to call the receipts. Actually, the YouTube community didn't coin that phrase. The YouTube community just uses that phrase, but the receipts, Whitney. Fan flip. I don't have a fan. I have a gavel. Wait, can I gavel flip? If I hit myself with this, because I have been drinking, I am going to be very embarrassed, and then I'm going to call Peter and blame it on him. The receipts. Gavel flip. On brand. Or proof where he was and what he said. Charles's receipts showed that the most damaging of Miss Westbrook's statements in the video were not truthful. I think that's still up for debate, but okay. Westbrook lost 200,000 subscribers in the following weeks to a decline to her present 8.85 million subscribers. If my channel could decline to 8.85 million subscribers, I would be thrilled. Thanks. I'll take it. Although she previously posted videos 5 days a week, after Carmageddon, Miss Westbrook began to withdraw from YouTube and began posting only 3 times a week, which is still a lot. Even worse, Westbrook did not defend the truth of her statements. This gets into Dramageddon and Carmageddon. This gets into the conversation they had in 2017, the response to the LA complaint, more defamation. The Westbrooks sued the YouTube commentator who broke the Los Angeles lawsuit, who broke the story. On October 30th, 2021, 10 days after Swanson filed the LA suit, the Westbrooks sued YouTube personality Katie Joy Paulson for defaming them. That's the case. The lawsuit was filed 2 days after Paulson uploaded a video on YouTube titled "I Was Right About Everything," a huge story coming on Tati Westbrook, and alleges that Ms. Paulson devoted numerous hours of her content on YouTube and numerous Twitter posts to discussing the LA complaint. Then we get to the Tati's public defamation continues. This is their alleging Tati's defamation against others. Oh, I forgot I was in this. That's right. I'm a footnote. Wait, where's my footnote? I actually did forget that I was in this. Plaintiff is informed and believes thereon alleges on August 28, 2020. A letter was published through a different attorney, Michael Saltz. Mr. Saltzy was the attorney representing the Westbrooks in their case against KJ. According to another YouTube legal commentator, I am a YouTube legal commentator. Thank you for getting it right. Emily D. Baker, she received the letter from Tati Westbrook's lawyer, whom she called to discuss the defamation case. Kind of, but no. According to Ms. Baker, after discussing the defamation case, no, I asked about jurisdiction. That was it. She then asked the lawyer about the LA suit. The lawyer said that he could not really speak to it and provided Ms. Baker with the August 28th, 2020 Fuchs letter. No, Fuchs. I know it's Fuchs. We're calling it Fuchs. It's fine. Ms. Baker published the letter to the YouTube community, and the video has been viewed over 246,000 times. The video is now down. They asked me to remove it. But then this lawsuit attaches everything that's in that letter. Everything in that lawsuit is attached here. So that letter is all in this. So yeah, it's just, I forgot. I haven't reviewed this in ages. We need more. We just need more. They say this false publication was repeated by numerous other commentators on YouTube and other media. What other media? See, Tati Westbrook exposes the truth about her lawsuit from Truth Sleuth. Hey, Truth Sleuth. And Tati finally responds by Angelica Oles. Hey, Angelica. And then Tati a year later, that's a different footnote. On June 17th, 2021, Westbrook published a video titled "A Year Later." In this video, Westbrook states, "I was recently informed that Clark Swanson has been feeding information, disparaging information to drama channels about myself, my husband, my family, info on Halo Beauty, financials, pipeline of product launches, and stated that Swanson was guilty of sabotage." I am not going to sing the Beastie Boys, but that's what's happening in my head. And that is also kind of alleged in the Nevada suit, where they talk about corporate duty and that information being shared. Truth Sleuth, you are in there with a hyperlink and everything. T-Spill and Truth Sleuth and Angelica. So, good company to keep. Causes of action: defamation, libel, from the statements about Swanson attacking his character and reputation. Second cause of action, false light, which is in the realm of defamation. Third cause of action, invasion of privacy. Fourth cause of action, civil conspiracy. And then prayer for relief. So this is the Swanson suit filed by his attorney in Washington, Emily Harris. Let's get to the response from the Westbrooks. I'm going to swoop again just so we can timestamp the Westbrooks response. The Westbrooks respond. Clark Swanson versus Tati Westbrook, James Westbrook, John Doe, Jane Doe. Defendants Tati and James Westbrook's answer affirmative defenses and counterclaims. We're going to focus on the counterclaims for the First Amendment complaint. The substance of the First Amendment complaint's not different. It's just the exhibits, the receipts. The reason I pulled this one up is so if we needed to refer back to it, we absolutely could, because we really might need to pull it up because it's got some of the information in there, but we'll talk about it. What's up, Topsy? Good to see you, girl. You put Epicon in there, and I was like, girl, that's my boo. What's up, friend? Good to see you. All right, we're going to keep drinking and reading. All right. Answer for their answer to the plaintiff's FAQ. Their First Amendment complaint. Defendants Tati and James Westbrook admit and deny and allege as follows. Summary of the complaint. And this depends on jurisdiction as to whether you have to admit and deny by each paragraph or just do general denials. We don't go over a ton of answers because when the answers are general denials, it's like we deny all that shit and we have a lot of defenses, and it's a blanket of every civil defense you can have so they don't miss anything. We don't go over those because they add no information. This has a cross complaint, meaning they're cross suing Swanson. So there's more information in it than we have already, which is why we're going to go over it. They go into what allegations they deny. The parties, defendants lack information to admit or deny the allegations on this paragraph. And that is how the whole thing goes, and we'll go through it quickly. Defendants admit that Westbrook is a YouTube celebrity with millions of viewers. Her Instagram handle is Glam Life Guru, and that XO's Tati has been her customary closing salutation for many years. Defendants further admit that Westbrook's channel focuses on reviews. Like, yes, that's what we do. That part is correct. Defendants admit Miss Westbrook holds 1/3 of the voting shares in Halo. Defendants are without knowledge as to how Mr. Westbrook could have a beneficial interest in future venture that does not exist and therefore deny the same. Defendants admit that Mr. Westbrook is a shareholder, and defendants deny the remaining allegations of this paragraph by paragraph. Defendants admit that the content of any statement made or signed under penalty of perjury speaks for itself. Defendants deny that Ms. Westbrook stated she sold her Bellevue condo, nor would she, since what she actually previously stated under penalty of perjury in December 2020 was that she was leasing a condo. This was in the Washington lawsuit against KJ with regard to jurisdiction and domicile. Do you remember all the fighting over domicile? Do they live in California? Do they live in Washington? And in that, they said they were leasing a condo. They attached a copy of the actual lease to that declaration and redacted out everybody's name, including the dog. And not all of the names. Tati and James's names are in there. The address was redacted out. Defendants admit that they remain in the greater Seattle area. Defendants lack information to admit or deny the rest. Jurisdiction and venue. Here, he sued here. We're countersuing here. Operative facts. Defendants admit that the lawsuit with case number 20 SMCV 01573 was filed in LA. The contents of any complaint referenced in the paragraph speak for itself, like the complaint. In addition, the complaint referred to in this paragraph is a verified complaint despite the shade. Verified complaint means signed under penalty of perjury. Despite knowing that the Westbrooks previously had moved to Washington, in that verified complaint, Swanson falsely stated under penalty of perjury that it believed they were still living in LA County and were citizens of California when that verified complaint was filed. Look, allegations and shade. Lawsuits are allegations and shade. Additionally, that lawsuit appears to be the result of form shopping because it was brought on behalf of a Nevada entity. Nevada law does not place a fiduciary duty obligation on LLC managers, whereas California law does impose such an obligation. Defendants deny the remaining allegations in this paragraph, and then they go on to the other denials. Defendants admit that Halo Beauty has been highly successful. Great. They go on paragraph by paragraph. Defendants admit that Doug Fuchs is counsel for defendants relative to the lawsuit instituted by plaintiff in California, and that Fuchs wrote and sent a letter with numerous exhibits which are missing from plaintiff's FAQ, but were attached to plaintiff's original complaint. It's interesting that they took the exhibits out. Dated August 20, 2020. Defendants deny the remaining allegations in that paragraph. Defendants admit Exhibit D is the letter. Defendants deny the allegations in this paragraph. Defendants deny that Swanson acquired wealth. They're just taking an opportunity to throw shade, which, look, the thing about these lawsuits that is sad to watch is that they were friends. They went into business together. By all accounts, the business is successful, and all of this devolved and is just going to be very expensive mudslinging with like mutually assured destruction. And it's just, it's just. So here we go into the allegations and shade. Defendants deny that Swanson acquired wealth through hard work. Deny that Swanson has a rigorous work ethic. Deny that Swanson's efforts have resulted in any successful business enterprises. They have to deny each paragraph specifically, and they are just taking the opportunity to deny it. Just deny that Mr. Swanson's net worth was easily sufficient to fund the necessary obligations. Deny that Swanson is a skilled businessman. Defendants admit that Swanson financed in whole or in part his capital contribution. Defendants deny that they had knowledge of Mr. Swanson's decision to finance his capital contribution at the time the action was taken. Had Mr. Swanson's decision to finance his capital contribution not been concealed from them, defendants would have objected and would not have gone into business with Mr. Swanson. Defendants deny the remaining allegations. I like that they took the chance to say, we deny that you're a skilled businessman. We deny that you work hard. We deny that you have a rigorous work ethic. Cause shade. Defendants deny that the letter attached as Exhibit C to the First Amendment complaint makes any false claims. Defendants admit that Swanson had disclosed to Mr. Westbrook on numerous occasions that he was struggling with an addiction to Klonopin. How else would he have known? Defendants further admit that this disclosure was disconcerting to them. They admit that they were troubled. Defendants deny any remaining allegations. Defendants admit they were aware that Swanson was taking Klonopin, but deny it was exclusively for treating tinnitus. Mr. Swanson made several disclosures to Mr. Westbrook because they were friends about Mr. Swanson's acquisition and misuse of prescription drugs. Why can't we speak? Whiskey. Prescription drugs, and complained that when he was not taking it, he would suffer from anxiety. Defendants admit Mr. Swanson informed Mr. Westbrook that Mr. Swanson was attempting to taper off his use of Klonopin by taking lower doses. But Mr. Swanson stated that he struggled. They're just laying it all out. All of it. But Mr. Swanson stated that he struggled and often was unsuccessful with reducing his use of the drugs. So they're laying out why they think it was an addiction. Defendants also admit that Swanson complained frequently that the manufacturer of Klonopin should be held liable for not disclosing the drug's addictive properties. They're just all in. And that someone needed to file a class action lawsuit to teach them a lesson. Defendants deny the remaining allegations. Defendants are like, would you like us to tell you more? Let us tell you more. We're going to take every opportunity to just throw it all out there. The allegations in this paragraph had no legal significance. You were wrong. To the extent that this paragraph requires a response, defendants deny. It's like, we have to respond, but this is stupid. So we deny. The allegations in this paragraph have no legal significance to the claims made by plaintiff. This is dumb. To the extent that this paragraph requires a response, defendants deny acknowledgement of activity constituting praise. Further, to the extent this paragraph relies on an alleged transcript or content of an audio recording purportedly taken by plaintiff, defendants did not consent to such audio recording, yikes, and deny the contents and authenticity of any alleged transcript of such recording. The recording is going to come up more because Swanson is saying there's a recording that says how we agreed to all of this. That's what should be filed. And the Westbrooks, and I have said in covering the LA lawsuit, is like, but the forms that you filed, the documents we have seen don't match up. So I asked frequently, was the recording consented to? Swanson has filed things in court that says the recording was consented to, and the Westbrooks are now saying that that recording was not consented to. That happened in California, so we will get to it. It's in their cross complaint. They go on to say the allegations in this paragraph have no legal significance. Your Honor, they're just being shady. To the claims made by plaintiff, to the extent that we are required to respond, defendants admit that the letter attached to the FAQ as Exhibit C is a written document. The letter is a written document that was prepared in anticipation of litigation. Defendants further deny any remaining allegations. This goes on with the same about the audio that we will get to more. Again, allegations have no legal significance. Allegations have no legal significance. The authenticity of the transcript we question, and they repeat that paragraph over paragraph. To the extent this paragraph requires a response, defendants admit that Ms. Westbrook is the most important component of Halo Beauty. Defendants further admit that Ms. Westbrook took a hiatus from social media. Defendants deny that Ms. Westbrook withdrew support from the Halo Beauty brand during this period. She was actively involved with the business operations of Halo Beauty during her social media hiatus. Rather, a decrease in Halo Beauty sales primarily stems from Swanson's obstruction of the business development and destruction of his business relationship with the defendants, his betrayal of the defendants, and his filing of the California lawsuit that falsely accuses defendants of various nefarious actions. Defendants also deny that Swanson ever managed the day-to-day operations of Halo Beauty with any amount of skill. Ouch. And defendants further deny that they ever praised Mr. Swanson for such management. Defendants deny the remaining allegations in this paragraph. Further, to the extent this paragraph relies on an alleged transcript, we deny that shit too. The allegations in this paragraph have no legal significance. Defendants admit that they engaged in negotiations of certain business arrangements regarding Halo Beauty on or about August 1st, 2017, which negotiations thereafter continued for several months. Ultimately culminating in a written agreement between the parties of the terms to which they were willing to be bound. Well, that matters. Look, here's the thing. What they're saying in this denial is, look, we had a conversation on August 1st, 2017. That conversation is the one that was recorded allegedly with permission. They're denying permission. But that negotiations happened over several months. So if negotiations happened and then were memorialized in a writing, the writing controls, not the initial conversation. You start a negotiation here, you end a negotiation here, you put it in writing, and that's what controls, not the other stuff. Ugh. But we kind of suspected this because we've been talking about this since the first LA lawsuit where Swanson attacked the corporation documents that didn't say what he's saying. What he's saying is he got all of Tati properties forever. And what they're saying is, no, that's not why we changed it around. And what the corporate documents in the first suit reflected was not that he was entitled to a part of Tati Beauty, in my opinion, based on reading what was attached to that lawsuit. Now, it seems that there's lots of other information that we don't have because now there were months of negotiations culminating in a written agreement between the parties. That means they had an initial conversation. Then they went to the lawyers and said, we want to do this, make it happen. Well, that's new information, isn't it? Further, to the extent this paragraph relies on an alleged transcript, they deny that that was properly recorded. Let's see. Defendants admit that the content of Exhibit D speaks for itself. Defendants admit they have nothing to be ashamed about. Great. Defendants deny the remaining allegations. The writing in this is cheeky. And this, by the way, this is Jeff Blanco, who you all will remember from his appearances in the Tati Westbrook versus KJ defamation suit in Washington as Washington counsel. Defendants admit that the LA lawsuit received media attention, especially... Oh, no. More shade. Sorry, mods. I know we're almost 2 hours in. We're just not done. We're just going to keep going till we're done because there was a lot to cover tonight. Oh, my goodness. Defendants admit that the LA lawsuit received media attention, especially since Mr. Swanson was sending the complaint attached as Exhibit A to the FAQ to others with instructions to break the story. Take a drink every time someone says break the story. I think we're 3 in at least. There's going to be more. With instructions to break the story about the existence of said lawsuit, defendants admit that the media attention was overwhelmingly negative towards Miss Westbrook. However, despite Mr. Swanson's boasting of his sabotage of Miss Westbrook, defendants deny that her subscriber base went into a nosedive. Defendants lack information to admit or deny the remaining allegations. 37, the allegations in this paragraph have no legal significance to the claims. To the extent that this paragraph requires a response, defendants admit that Miss Westbrook uploaded a YouTube video titled Bye Sister. Defendants deny that Miss Westbrook made defamatory statements about anyone or avowed any stereotypes. Defendants are without sufficient information to admit or deny the remaining. The allegations in this paragraph have no legal significance. To the extent the paragraph requires a response, defendants admit that James Charles posted a video titled No More Lies, which is now considered by the general public to be filled with falsehoods. Oh, fuck. Oh, no. Wow, we're into all of it. Yep. We're nosediving into all of it. Look, if y'all missed Dramageddon and Carmageddon, we're back. We are back. Oh, Ashley said, Emily trying to get me drunk off my root beer. Look, I'm drinking root beer flavored whiskey, so don't worry. I'll just do it. Okay, let's get into the James Charles shade because, woo! They opened the door for this. They opened the door for this. Defendants admit that James Charles posted a video titled No More Lies, which is now considered by the general public to be filled with falsehoods, as there have been multiple reports of James Charles's inappropriate behavior that have come to light after No More Lies was posted. Defendants further admit that Miss Westbrook has 3 million more subscribers today than she had before uploading the Bye Sister video. Her channel is considered one of the most popular YouTube beauty channels in the world. Defendants deny that any statements in Bye Sister were not truthful. Defendants are without sufficient information to admit or deny the rest. Defendants admit that Ms. Westbrook's YouTube content speaks for itself. To the offense that the allegations in this paragraph differ from that content, defendants deny the same. Defendants further admit that Ms. Westbrook reduced her number of posts per week, but deny that the change occurred after James Charles' posting of No More Lies. Rather, Ms. Westbrook began reducing her weekly number of posts in January 2019. Didn't she make a video about that? I mean, I feel like she made a video saying, I can't do 5 days a week anymore. 5 days a week is insane. Miss Mia is saying, while Tati's lawyers woke up and chose violence. I think Jazzy Jeff is like, look, we can't give Salts all the fun. Like Jazzy Jeff is like, I will bring the action. Let's do it. And I remember her making a video saying why she was going from 5 times a week to 3. I mean, I imagine if you look at her channel, you can find this. Defendants admit that Ms. Westbrook's YouTube content speaks for itself. Let's see. This paragraph has no legal significance. The audio recording we don't admit to. The allegations in this paragraph have no legal significance. Defendants admit that their Halo Beauty Partners LLC lawsuit against Katie Joy Paulson and Without a Crystal Ball was dismissed on March 14th for lack of personal jurisdiction. Defendants admit that Douglas Fuchs, it's hard. Look, Douglas. There is no shade. You work for a very prestigious law firm. I am sure you are a brilliant lawyer, and the letters that you wrote were savage and filled with receipts, and we appreciate them. But this is a channel for cursey words, and your name is spelled so closely to fucks that it is very hard for me to restrain, and it is not with any disrespect. It is with all due respect, because we are just building the law firm of Salty Fucks and Jazzy Jeff with peace and love. Can you imagine? Would you go to a law firm named Salty Fucks and Jazzy Jeff? Because I think you would. I might. I'm sorry. Look, it's been a long week, and we're amused here. Sorry, Douglas. We apologize for being childish. They admit that Douglas Fuchs is their lawyer in California, and that in anticipation of litigation, Fuchs wrote a letter to plaintiff's counsel dated August 28, 2020, which is attached to the FAQ, minus the exhibits. As Exhibit C, defendants deny that they published a letter written by Ms. Fuchs. Defendants further deny that the letter was a settlement letter and deny that the letter was sent directly to Mr. Swanson. No, wasn't it sent to his lawyers? Defendants admit that Michael Saltz was one of the attorneys representing defendants in the lawsuit filed by defendants against KJ and without a crystal ball. Defendants are without sufficient information to admit or deny the rest. Defendants deny that the August 28, 2020 letter containing any false statements. Defendants are without sufficient information to admit or deny the rest. Admit, paragraph 48. Defendants admit that Westbrook's YouTube content speaks for itself. Defendants deny that such statements were made. Further, defendants specifically denied that Ms. Westbrook stated that Mr. Swanson was guilty of sabotage. Defendants, it's sabotage. Defendants deny the allegations in this paragraph. Further, the allegations in this paragraph are internally inconsistent. Ooh, that's lawyer shade. Like the lawyer shade, internally inconsistent is like, but you said something different over there. So inconsistent. With the allegations contained in paragraph 46 and others, which acknowledge that unlike Mr. Swanson, Ms. Westbrook never fed any information to, quote, drama channels. Defendants admit that Ms. Westbrook's YouTube content speaks for itself. And then we get into the causes of action. Deny. Look, these are general denials. Deny, deny, deny. Deny, 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 deny. Affirmative defenses. These are all the affirmative defenses that are possible. We're not going to get into latches and unclean hands. They are all alleged here. No shade there. These are all of the defenses. All of the defenses. Counterclaims is where we're going next. Counterclaims are a lawsuit within a lawsuit. It's kind of like lawsuit inception. It's like, hey, you sued me for that? Fine. Fuck you. I'm suing you for this. And that is the law nerd definition. The law nerd definition of a counterclaim. What's a counterclaim? Oh, you sued me? Yeah? Well, fuck you. I'm suing you too. It works. Parties. Tati Westbrook resides in King County, Washington. James Westbrook resides in King County, Washington. Clark Swanson, upon information and belief, resides in Clark County, Nevada. Does Nevada, hey, Nevadians, in the states here, they put your county on the back of your license plate. Does Clark Swanson have a license plate that just says Clark on the back of it? And if so, do you think Clark Swanson has a personalized plate that says Clark and then has like the Clark County sticker? Because it would be like Clark. Do you think? I mean, I think that would be brilliant. I want that to be true. Tangent, my brain. Apologies. Jurisdiction. Hey, you have jurisdiction here because you sued us here. Facts. We love facts. Facts. Swanson and the Westbrooks own a nutraceutical business. Every time they say nutraceutical, I feel personally attacked. It's such a hard word. It's so long. Can't we just say vitamins? No, it's fancier than vitamins. It's nutraceuticals. The Westbrooks, just get ready. Buckle up. All of it. We're getting into just buckle it up. We're getting into all of it. The Westbrooks often were embarrassed by Mr. Swanson's conduct in the Halo Beauty workplace. He was grossly inappropriate and unprofessional. Do you remember when we went over the letter that is attached now to the complaint where they were talking about being embarrassed by Swanson's behavior with Jeffree Star? Do we all remember those moments? There were screenshots. In addition, Mr. Swanson's behavior towards Miss Westbrook was disturbing to the Westbrooks. When working in the same space, Swanson inappropriately touched Miss Westbrook without her consent. For example, coming up behind her and grabbing her waist. Humans, don't do that. Don't do that. Rubbing her shoulders, that's a big negative unless you have that relationship. And back, hovering over her from behind, that always makes me uncomfortable. Sitting next to her and grabbing her thighs or rubbing her feet. Negative ghostwriter. That pattern is full for me. I have had people in the workplace just personally do all of those things. These are allegations in a lawsuit. These allegations were also voiced in that letter that's attached to the lawsuit here. It wasn't said that it was with regard to Tati. In the letter from the lawyers in the pre-litigation, because it was a derivative claim in the LA suit that's now attached in this suit, it talked about the shoulders in the back, but it didn't say that it was Tati, to the best of my recollection. We can pull that up. It's attached. But yep. Swanson, they are alleging, continued to engage in his inappropriate touching of Miss Westbrook, despite the fact that Miss Westbrook expressly and repeatedly told Mr. Swanson to stop touching her. Can you imagine if you were like, look, if you're Tati and you believe this is what happened, because again, allegations, we weren't there. And you're like, we've had this conversation. Like, we've had these problems. We've told you not to be in our company. And then you're going to sue me. And then you're going to send me a demand for like $30 million plus or something. And then you're going to leak it to drama channels. And then you're going to say that I'm greedy. And then. Can you imagine how you would feel? I can. The frustration. But again, lawsuits are allegations. All right. Take a breath. If you haven't buckled up yet, just click it in. Look, Jazzy Jeff was like, okay, fuck this. All of it's going in the counterclaims. We're putting all of it in here. We deny that you were a good businessman, and we're going to talk about the workplace behavior that we believe is inappropriate and we are alleging against you. Swanson continued to engage in his inappropriate touching of Miss Westbrook, despite the fact that she expressly and repeatedly told him to stop touching her. Swanson also made demeaning comments to Miss Westbrook, shamed her, and yelled at her in front of others. By way of example, Swanson would talk down to Westbrook, tell her that she was incompetent to run the company, and make comments to the effect of women are too stupid and not wired to be effective leaders. Okay. Ultimately, after several unsuccessful interventions, the Westbrooks determined that Swanson's erratic behavior and inappropriate physical touching and comments directed at Miss Westbrook were not going to stop. In July 2020, the Westbrooks indicated to Swanson that they were planning to remove him from the day-to-day operations of Halo Beauty and not allow him to have any role in running the business. Swanson's response to this information was to sue the Westbrooks individually and derivatively in LA in a verified complaint containing false and salacious allegations and sham claims, and then threatened to ruin Miss Westbrook's reputation and career if the Westbrooks did not pay Mr. Swanson tens of millions of dollars to settle the lawsuit. And I made a note in the demand letter. And the demand letter, I think it was like 30 million. It could have been more. To be certain, Swanson's pre-litigation communications prior to the filing, the California West, it does say 30 million. I remembered properly, or I remembered because I just read it here. One or the other. To be certain, Swanson's pre-litigation communications prior to filing the California suit stated that he believed the settlement value of his otherwise sham claims to be approximately $30 million, plus all shares of Halo and 100% of Halo Beauty partners. So you guys are like, code red, DEFCON red. Okay, look, I hear you. I agree with you. We will go to DEFCON red. We have an animation for DEFCON red. We have not toned down the flashes yet. I mean, tech has edited it and got it to me, but we have not gone all the way in yet. So I have not corrected it all the way. So if you are flash sensitive, when the music stops, you are welcome to look back. It does flash a little. Most of you don't have a problem with it. That's why I give a flash warning. We're going to DEFCON red. We are red. All right. Let us proceed. Let us proceed with the stream. No, you didn't miss it. We did it. We are red. All right. Motion granted. Motion granted. Let's get back. Let's get back at it. Swanson filed the California lawsuit as a verified complaint. Yeah, he signed it, and his lawyer didn't, against the Westbrooks in LA County, despite the fact that Swanson and the Halo Beauty business were domiciled in Nevada. Therein, Swanson falsely claimed they brought that up like twice now, Swanson falsely claimed under penalty of perjury that the Westbrooks lived in California despite having direct knowledge to the contrary. So they're just like, oh, and he falsely claimed under penalty of perjury. On information and belief, Swanson filed said lawsuit in Los Angeles for the improper ulterior purpose of harassing the Westbrooks, impairing their rights to defend a lawsuit, and making it inconvenient for them to defend the lawsuit on its merits, in effect, coercing an inequitable settlement and forcing the Westbrooks to incur excessive litigation cost and expense in having to respond to the lawsuit in a county and state where the venue was inconvenient to defend, which the court agreed with because the court granted the motion for form nonconvenience. Last month, Swanson's filing of the California lawsuit in October 2020. Following the filing, Swanson gave said lawsuit to YouTube personality KJ with instructions to break the story. About the false and salacious allegations, this is a lawsuit because of the defendant's greed, contained therein for the purpose of creating negative and damaging media attention against the Westbrooks. Upon information and belief, Swanson similarly contacted other drama channels on YouTube. Then in November 2020, this shocked me. Just wait. These are allegations. Then in November 2020, Swanson called a childhood friend of Miss Westbrook. During said phone call, Swanson disparaged Mr. Westbrook by telling the friend that Mr. Westbrook had removed his mother from life support to steal his sister's inheritance, and that Mr. Westbrook and that Mrs. Westbrook should be worried for her safety. Where have we heard that allegation before? Just saying. During the same phone call, Swanson threatened that he had an embarrassing recording of Tati that he would release publicly to ruin her reputation and her career if she did not contact him immediately to settle the California lawsuit. Swanson told the friend to pass his threatening message along to Tati and that Tati must take action to resolve the California lawsuit or he would ruin her. Swanson further informed the friend that he also had reached out to members of the Westbrooks family to warn them that he had an embarrassing recording he intended to use to ruin Tati if she did not settle the California lawsuit. Well, if we need context for why she has shared how stressed she's been, I think the lawsuit is providing context of what the allegations are. Upon information and belief, the quote recording that Mr. Swanson referenced in the phone call and that was used to extort, that's a big word, to extort the Westbrooks, was an illegal secret audio recording that Swanson took of a confidential business meeting that occurred at Swanson's home in California between the Westbrooks and Swanson. The Westbrooks had no knowledge that an audio recording of their confidential communications was being taken by Mr. Swanson, which you can't do. Swanson and all of the other things said that he had consent to record. We're going to get there. We're going to get there. As a direct and proximate result of Swanson's conduct, including the illegal recording and extortion, the Westbrooks have suffered financial damages and severe emotional distress. First cause of action, outrage. Outrage. How much do we love an outrage cause of action? Not everybody has an outrage cause of action. Look, this is our first together. This is our first outrage. All of you, we are gathered here today to talk about the cause of action of outrage. Did I tell you all I did my first year of law school in Seattle? I did. Outrage. Outrage. Thank you, Belanco, for bringing us outrage. The Westbrooks allege and incorporate all the shit above. Swanson's illegal recording and extortion, as defined by Washington Criminal Code, RCW 9A.56.11-.130 of the Westbrooks, as described in this answer, affirmative defense's counterclaims, was extreme and outrageous and beyond the bounds of decency tolerated by a civilized society. By illegally recording a confidential business meeting without the consent of the Westbrooks and calling Miss Westbrook's friend to disparage Mr. Westbrook threatening the Westbrooks and attempting to blackmail the Westbrooks into paying $30 millions of dollars to him. Swanson intended to cause the Westbrooks severe emotional distress and or Swanson's conduct was perpetrated with reckless disregard as to the probability that it would cause severe emotional distress. As a result, Swanson's conduct, as described, has caused severe emotional distress. Second counterclaim, invasion of privacy under California common law. Because this happened in California. Swanson surreptitiously recorded a private business meeting between the Westbrooks and him that took place at Mr. Swanson's home in California. Again, Swanson argued that he had consent. They are saying that he didn't. This is a factual disagreement that eventually will have to be either resolved or settled by a jury. The Westbrooks had no knowledge of and did not consent to the recording of that confidential communication. Tati Westbrook has spent over 10 years building her personal brand and, like many public figures, is deliberate and careful in how she acts in public and how her public persona is presented and perceived. All YouTubers. For better or for worse. The illegal recording taken by Swanson contains information and statements that are damaging to Westbrook's brand and negatively impact her public persona that are now in all of the lawsuits. So like the shit's out of the horse on that one. But I think the context maybe sprays some poopery around the shit that's out of the horse. Perhaps the context helps. The illegal secret recording of the business meetings, business communications were taken for the purpose of blackmail or harassment of the Westbrooks. By secretly recording private business communications, Swanson intentionally intruded on the Westbrooks' solitude, seclusion. This is the language of the law that they're alleging. Solitude, seclusion, private affairs. And such intrusion is highly offensive to a reasonable person. Third counterclaim, invasion of privacy, interest protected by California state constitution, Article 1, Section 1. This is another section under which they are alleging the illegal recording. Fourth counterclaim, invasion of privacy under Cal Penal Code 637.2, violation of California Penal Code 632. The legislature hereby declares that advances in science and technology have led to the development of new devices. Ooh, boomer language. And technologies for the purpose of eavesdropping upon private communication, and that the invasion of privacy resulting from the continual and increased use of such devices and techniques has created a serious threat to free exercise of personal liberties. So again, illegal recording. It'll be interesting to compare and contrast when all of this comes up. In the Britney Spears case, when all of the illegal recording stuff comes up, to compare and contrast how they pled it versus how it's pled here. Just down the road. But it's 3 different causes of action for the same action of the alleged illegal recording. Fifth counterclaim, abusive process. That's the one that the language kind of leads you to believe is coming when they talk about the way that the California lawsuit was used from their perspective. The Westbrooks allege all the shit above. Under Washington law, the essential elements of abusive process are an ulterior purpose, a willful act in the use of process not proper in the regular conduct of the proceeding. Under California law, the elements of the cause of action for abusive process have been stated to be ulterior purpose and willful act. And then they cite Nevada as well. So under whatever jurisdiction you find, they're alleging that the California lawsuit was an abusive process. They say Swanson abused the process in the California lawsuit by knowingly and intentionally filing the lawsuit in an improper venue to harass the Westbrooks, impair their right to defend, coerce an inequitable settlement, and force them to incur excessive litigation costs and expense to respond to the lawsuit, and making it inconvenient for them to defend it on its merits. Upon information and belief, Swanson used the California lawsuit as a platform from which to publish to the media disparaging, salacious, and false material through his agent, Ms. Paulson, and other drama channels on YouTube to intimidate and pressure the Westbrooks into settling the California suit. Swanson further abused the process in the California suit by using such judicial proceeding to extort money from the Westbrooks in exchange for not releasing an illegal audio recording he asserted would ruin Westbrook's reputation and career and be embarrassing for her. Specifically, he contacted the family friend. We've gone over that part. As a proximate result of the actions of Swanson, the Westbrooks have been damaged generally, including financially, and having spent Hear me clearly. Hundreds of thousands of dollars to respond to the California lawsuit and otherwise prevail on a motion for form nonconvenience against Swanson in September 2021. I don't doubt that at all. Hundreds of thousands of dollars. And that is what everyone is going to be spending, that kind of money in these lawsuits back and forth across 2 states. Prayer for relief for the plaintiff's FAC to be dismissed, for the court to grant a judgment and award of damages in favor for the counterclaims. So with the counterclaims, they can get money because they're like, no, we're suing you for this. So if down the road Swanson loses his claim and the Westbrooks win, they get money. Otherwise, it can go the other way if Swanson wins and they lose. For treble statutory damages, just means triple. Injunctive relief, enjoining Swanson from releasing or distributing the audio recording or any purported transcript of such recording, even though it's in all these court documents. For injunctive relief, requiring Swanson to destroy the audio recording, all copies of the recording, and the transcripts. Pre- and post-judgment interest at 12%. Punitive damages under California and or Nevada law, recoverable attorney's fees. And that is from Jeff Belanco, Seattle counsel. And that's at 2 hours and 20 minutes. Is the end. That is the end. We're going to get to questions, and I think we should just do that now because we're already here. I have questions. You have questions. We have questions. Let's get to, oh, look, the whiskey's gone. Let's get to questions. I'm the reason the whiskey's gone this evening. The ice cube is also almost gone. My husband asked if I wanted to use the other whiskey glass tonight. I'm like, hun, I was on stream. They were drinking whiskey. I want to drink whiskey. Can you grab me a glass and a cube, as I was getting ready to come on stream? And he was like, sure. Do you want this glass or this glass? And I'm like, no, I want that glass with the cube. He's like, is that because it holds more? And I was like, yes, it's exactly because it holds more. Is this a slap situation? No. Washington State's slap statute was determined to be unconstitutional a number of years back. So no, there is no slap statute. So if you sue someone for defamation in Washington, they cannot file a slap statute. They have to allege the defenses and go through the discovery process, which is why some people can choose that form, nonconvenience there. Jordan, yes. Why is that? Yes, it was a reference to pirates. I love Disney. Ashley's like, there's a hole in the cup. No, you drink that from the top. I was just drinking it from the top. Too much. To me, it sounds a bit like it's 3 different states involved. So they alleged it under 3 different states' laws because the court can pick, and they will deal with that later. So yes. Question, when are we finishing the Britney filings? Well, we were almost done, but Tuesday we will get back to Britney. There are new filings. I wanted to cover these mostly because I'm kind of living for the shade in all of this. Look, if a lawsuit entertains me, I am more happy to cover it. If it's an absolute shit show, I am happy to make fun of it. And with how heavy things have been, like, this brings all of the shade. So I was like, what we're going to do is this. Question, can you legally have a nanny cam in California? They cannot be surreptitious. They have to be either pointed out or acknowledged. So, you have to acknowledge them, even in like Airbnbs and stuff, because people put cameras in Airbnbs. So you have to have notice of recording. No, Jamila, I adore you. No, I am not grabbing Dr. B to bring me more whiskey. I definitely don't need any more whiskey. Question, will other YouTubers who cover the Duggars be able to realistically be allowed to attend the trial? I've been asked on social media. I have not looked at it or thought about it. It'll be up to the court to decide. Yes, Jem, it was a Sweet Home Alabama reference, because how fucking great is that movie? I love Reese Witherspoon. I am convinced that someday she and I are just going to run into each other around Nashville, and I'm going to be like, oh my God, Reese, Emily, we should be friends. And she's going to be like, absolutely. Can we talk about Britney Spears? And I'm going to be like, yes. Can we go get whiskey and barbecue? In my head. That's going to happen. Can this lawsuit against the Westbrooks be thrown out because of the litigation in Nevada? No, the form's not inconvenient there. These 2 things I see running parallel, unless all the parties agree to swoop it into the Nevada litigation, which could happen. This court could be like, if everything's in Nevada, why isn't this in Nevada too? So, but no, they're not asking for that to be done. They didn't make any pre-litigation motions. They answered the complaint and were like, fine, we're cross-complaining off and away. Off and away. Um, top 3 whiskey recommendations. I always stick to what I know. I want to venture out. I am also venturing out. I really like Angel's Envy. I really love the flavors from Old Smoky. They have great flavored whiskeys. I love a flavored whiskey. This was root beer. We've got salted caramel and watermelon. They have great flavored whiskey. And then I forget the name of the Tennessee company. There is a Tennessee whiskey that is not peanut butter whiskey, but peanut butter cup whiskey that has a chocolate aftertaste with the peanut butter. And it is so divine. It is so divine. So those are my top 3. Question, can this be pursued for the illegal recording and blackmail attempt? That's what they're doing here civilly. I don't know if they will pursue it in any other way. I have no way to know, but that's why these allegations are here. For whiskey and nerd lovers, you can get giant Death Star ice molds. We lost ours in the move, but I have been intending to buy new ones. So I've absolutely been intending to buy new ones. Question, I hear that Jamie Lynn has been making some negative comments about Britney. That's not smart. What are your thoughts on that? I haven't seen it, but I don't know why they would do that. Do you think Britney will be able to sue everyone who helped harm her? I don't know what her choice. Look, I don't know what her choice will be. Can she sue in some cases? Probably. Will she want to go through the money and the mental energy and the drain that this takes? I don't know. She might want to just be like, fuck you, bitches, I'm out, which is kind of what we saw on Instagram that I talked about on Tuesday. It was like, hey, whether or not, I think there will be an investigation. I think that some of that will be pursued potentially, or at least turned over to be pursued criminally. I think that's a desire that Rosengard has made clear. But will Britney want to civilly sue everybody? It'll be so much time and energy, and I don't know if she's going to want to do that or if she's just going to want to move on. So I don't know. Shout out to the mods for always killing it. Yes, thank you to the mods for killing it. I know we had a very busy stream tonight, and they do a great job because I put rules in place to keep the Law Nerd community the greatest place on the internet, in my opinion. So thank you, Kaylin, for that, and thank you to the mods. You guys are welcome to show some mod love in the chat. I need to look back at some of the older super chats. I know I missed some while I was talking. I try to get to them as best as I can during this part of the stream, but let me go and see if I can pull some of those up while I'm answering more questions. Question, do you think any of Josh's siblings will have to testify? If so, how many? I don't have any estimation of how many. It depends on what they know. I think it's possible and highly possible that some of them will testify, depending who he was giving information to and who he was talking to about this. I mean, I definitely think it's possible. How many? I have no idea. There's a lot of them. I have no idea. Questions. Question, can California on their own punish counsel for the cross complaining for bringing a suit to harass? The state of California? I mean, it's very rare that the state of California brings something. I mean, we're seeing that in like the Blizzard lawsuit, but California on their own can't punish counsel for a cross-complaining. In this case, is Tati Westbrook for bringing a suit to harass. I mean, I don't think that's what they're doing here, but can California punish lawyers for doing things? I mean, they're supposed to. My thoughts on whether they're doing it or not is a whole different thing, but they're supposed to. But that's different. And there would have to be reports. I don't think anything that's been done here is outside of the bounds of professional conduct. So that is what we're talking about. There is a good peanut butter whiskey out of San Diego that's also good. Yeah, is it the Black Sheep one, or it's the one with like the sheep on the label? So watermelon whiskey, yeah, it's salted or salty. They call it salty watermelon whiskey. It's delicious. That's what I was talking about. Screwball. That's the one I think that is being referenced, the San Diego whiskey, the one with the sheep on it. Yes! Thank you, Gilda. Tennessee Legend, peanut butter cup whiskey. That's what was in my brain. This is why live streaming is so great. That one, it's so good. And they have them in California as well. I don't know where else they have them, but it's very good. Question, wasn't the sneaky recording in California, therefore the California case? It was in California. That's why they are referring to it in this case under California law, because it happened in Marina del Rey. It was brought up in that case later on in the case, but it was really brought up in the Washington case. They brought up the recording and said, look, this is part of the defamation because this is what was in that call. So it came up most in this Washington case, if that helps. So let's see. I will go look for Sloan's report of what Jamie Lynn is. If it's not happening in court documents, I tend to not follow it as closely just because the court documents have been popping off. There's been so much. You guys, I'm going to try to get to all of the super chats. Celine, thank you for the super chat. Hello. Matt Bond, I will absolutely boop the floofs. They are probably with my son tonight because they climb up on his desk while he's gaming and they were in here all day. So I think that's where they are. Let's see. Stars said, it's been a year. My baby girl turned 1 year old. I found your channel in the hospital the day after I had her. You kept me company in my room. Well, happy birthday to your baby girl, Stars. And thank you. Matt Bond, Emily lost for words, get out of town. It does happen when I talk about how much I love this community. Amy said, thank you for this community. These are my people. Same. Skylar said, what's your opinion on TriStar and Lou Taylor blocking Rosengard on his request for files? Well, they are attempting to, and we're going to talk about it Tuesday. I have all the thoughts, but we had to get to this first. 200 Watt Studio said, saw you on Nick's stream. Love you. New member, welcome and thank you. We do things a little different than Nick does, but that's okay. All communities are different. Amy Yost says, well, need a break from studying rules of evidence. And by studying, I mean cramming for tomorrow exams. Well, we have lots of rules of evidence tonight. I hope it was helpful. Lone Wolf Ranger, new to the channel. Thanks for covering. Have you mentioned the trooper who helped Josh is in Club Fed for possession? I have no idea. I have no idea. I have not mentioned it. I do not know. You are welcome to DM me. So you are welcome to DM me. Jamie asked me a question about KJ. I really try not to comment on what she is or is not doing because I find people can take things out of context. And the super chat is that she's saying she can make her own press pass to attend. Look, she has to contact the court just like anybody else, and they have to go through the proper channels to attend a trial, but each court has its own procedures to do it, just like with the Britney cases. Aria said, would the courts grant Anna a divorce if she filed for one under these circumstances? I mean, it depends. Anyone can get a divorce granted when they file for it. It just depends on how much time it takes, contested versus uncontested. I've never seen a court say, no, you may not be divorced. But if it's a contested divorce, it'll just be a period of time. Taz said, hello from Ireland. This is what I needed after a hard week. I'm so glad. Deanne said, can an attorney fire a client if the client constantly refuses to take their advice? It really depends on circumstances, and it cannot happen on the eve of trial unless something drastic happens, like the client tries to kill the attorney or something like that, which I'm not suggesting has happened in any of these cases. It's very rare for a criminal defense attorney to leave. Look, criminal defense attorneys know that their clients have the right to make some decisions, but not all. And that's what they're getting paid to do. It's one of the things that can be hard about being an attorney. You're like, but I want to do this. Let's sue them. And your client's like, no, can we just please send a cease and desist? And you're like, but we should sue them. And they're like, no, we're not going to do that. And you're like, okay, no, we're not going to do that. So that is their job. That is what they are getting paid to do. But yes, sometimes there are circumstances where an attorney can fire a client. Sierra Daly said, sending my love from Ireland to everyone tonight. Thank you. Pam Marshall, at this point, Duggar should just blame the car lot poltergeist. I mean, the government didn't exclude him from blaming supernatural activity. It's not in any of the motions. I said sarcastically. Brandy, question, have all the members' tumblers been sent out? I haven't received mine. 3L Patreon member. I worry it got lost in the mail. I will go look and see if you messaged me and try to find it and go track your number. There are a few last international ones where I had to redo some of the forms for customs. Sandy said document fund. Thank you. Matt Bond, I need a signed copy of your page. Okay. Simply Simple said, question, Emily, is it possible for you to have Tati as a guest on your channel? Not until these lawsuits are done, and even then she might not want to talk about this stuff. Tati mentioned the possibility of reading and reacting to the legal filings on her video, clearing the air Q&A. She may choose to do that. She is involved. I think it would be hard to air all this out when you're involved in it because it can be very emotional. From the outside, it's a lot easier. We're detached. This doesn't affect all of our day-to-day lives. It very much affects theirs with the amount of money that they're spending, particularly, and the fact that they're having this complete meltdown of not just a business relationship, but a friendship. There's a lot of layers to that. So I mean, I don't think that's a possibility anytime in the near future. And once these lawsuits are done, I mean, you never say never, but these lawsuits need time to resolve. And for now, we'll just be over here covering them and talking about Jazzy Jeff, I guess. Trish Lippy said, damn, Jazzy Jeff's not messing around. No, he went in. I imagine that there is consultation in this, but Jazzy Jeff's been around since the beginning of the other Washington suit. Like, there's at least 3 firms involved in all of this stuff, if not more, because there was LA Council plus Salts plus Washington Council plus Nevada Council. There's a lot of lawyers involved in this. Let us get to a few more questions, and then at 2 hours and 30 minutes, we are going to have to bounce because, yeah, it's been a long night. So what are your comments about the Real Housewives of Beverly Hills reunion and Erica? I'm going to do a longer I Have Thoughts podcast about that over on Patreon, just because I need to rewatch some of it. I think that she tried to answer the questions. I think that we learned that Erica is where she is. She is very frustrated that all these lawsuits are pointed at her. Some things have changed in those lawsuits very quickly. Like, her and Ron Richards are now against Jay Edelson. It's like, wait a second. There's a lot happening in those lawsuits, which we will also be getting to next week. But I think the same thing I thought at the beginning. She's worried about her, and she's going to do what it takes for her to survive. I think she tried to answer the questions. I think she's I think she's really angry that anyone would question her ever. And I think the ladies were right to question her. I don't think they were wrong at all. So, thank you. I have fallen in love with watermelon margarita. It's awesome. Yes. Yes. Oh my God. I love York peppermint patties. I don't know what that's in relation to, but I love it too. Hopefully it's a whiskey flavor. I would totally do that. I sent you a case about a doctor, laserizing his name in organs he transplanted. What? Ashley, I will go look for it. That's wild. We also are going to be covering the Chalene Johnson defamation lawsuit on this channel, for sure, because she is in a defamation suit with a plastic surgeon that is very interesting. So, yes, we have a lot. Yeah, we'll have a surgeon day, it sounds like, because we'll have much to do. Question: this recording, if I understand, this recording, if I understand it right, was made by Clark Swanson at his home that is in Nevada. That is a one-party consent state. Paddock, it was made in Marina del Rey when he still lived in California. That's where the business meeting was, based on other court documents. It's not really clearly explained in this. He moved to Nevada after that, and California is a 2-party state. I think Swanson will argue, because they brought it up a lot, that it was on a patio. I think they're going to argue there was no expectation of privacy. I think there will be arguing over those causes for sure. Question, I think you kind of addressed it already, but have you seen any written agreements proving Swanson was getting a cut of Tati Beauty, or just the disputed initial verbal agreement? There is a document in one of the filings that I had trouble with, because that document indicated that there was an agreement, but then the corporate formation document and that document weren't consistent with each other. And I still don't understand why they're not consistent. From what this new filing said, is that there was that conversation on the patio and then months of negotiation and then a formal agreement. Whatever that formal agreement was, we haven't seen, because I don't think it's the meeting minutes, because it would have been called minutes. And I don't know if they're referring to the corporate filing, because we have that in the first LA lawsuit and it's attached in the new lawsuit. And it doesn't indicate anything about Tati's other properties. It only indicates the ownership percentages and that they can't have competing nutraceutical businesses. That's all it talks about. And that was attached to the first lawsuit. And when we went over that, I was like, but this doesn't say that. Like, this document doesn't say that. And Swanson's been saying, no, this says that. But if there's months of discovery or months of, sorry, I saw the question below, but if there's months of discussion and then the corporate document's the one that's formalized, then the other conversations are irrelevant. It's just the formal agreement, the written agreement that controls. So that's, Jordan, it's in dispute. There is conflict. There's in dispute. I believe that the corporate one is the last one in time. So that one, in my belief, is controlling, but we don't have everything. We only have what's been filed in court. So I will be addressing that next week. I haven't read those documents yet because I've been reading all of this stuff. So yes, we will absolutely boop the floofs for sure. Question: if they don't have the Westbrooks acknowledging the recording on the recording, does the court have to assume there is no consent? The fact finder would get to decide if there was consent. So no, the court wouldn't have to assume that. So that. So let's see. Is Brittany not being covered? Not tonight. Brittany will be covered again on Tuesday. Thank you, Ashley Vincent. Tonight we had lots to do. And we are not topic agnostic over here with the Law Nerds. We cover so much stuff. Do you think I can summon the cat to the room? I don't. Nope. Hey, Fred. The Law Nerds miss you. Nope. I guarantee you he's with T. So that. Do you have other merch items on Patreon? There will be, there aren't yet. Debs, no COPO. No, because I totally dropped the ball when Twitter wouldn't let me upload the brackets. So we're not done with our Halloween bracket. So a little late, but it might be great. So let me finish up with 2 more questions and then we're going to go. Question: did you start the Real Housewives book yet? If so, is it good? I have started it. It is good. I really, really, really like just Dave Quinn. I really like Dave Quinn. I really, really like the way that this is laid out because it's laid out by franchise with really interesting stories and they're interspersed in. So it's really conversational. And I just think it's fantastic. It's a big book, but I like the way they're going through the franchises. So I enjoy it. These are the 2 things I am reading right now. I am finishing rereading my critical thinking from the MIT Free Press because I always take something away from it, and Not All Diamonds and Rosé. All I want to do, though, to be honest, all I want to do is zoom, and a boom, boom. No, all I want to do is play Animal Crossing. Like, it's been days. It's been days, and I have not had time. And I have to record the podcast tomorrow so it can be out on time for next week. Because I didn't get to it today. So then I will be getting to Animal Crossing the rest of the weekend. It just needs to happen. So, will you be covering the Kyle Beach NHL case? I have not looked into it yet, so I will not say no, but I will also not say yes. I have not looked at it yet. So maybe. Maybe. So we will see. All right, Law Nerds. Thank you for being with me tonight. Thank you for hanging in there with respect. Thank you to our amazing mods that keep this community an amazing place to be, even when the streams are busy, because I know that it is hard. I appreciate all of you. I am going to go to bed so I can get up tomorrow so that I can absolutely finish the work I need to do. So then I can go and play Animal Crossing. And I am very much antsy to organize my closet. I don't know. It's been for like 2 weeks. I've been like, I'm interested in it. Matt Bond, did you find the Lawyer Joke book? Not yet. I have no idea where it is. And I'm very sad that I haven't found it yet, but I need to know where it is. So thank you all for the Bing. Thank you all for being here. If I keep saying goodbye, I'm going to say goodbye for 100 years. So it's just cheers. It's time to go. Thank you for being a Law Nerd.
Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.